Good day to all our law students and future pañeros and pañeras. My name is Luis from Arellano Law School, and I will be your host for today. Welcome to the Central Book's Best Pre-Week Ever. Our pre-week bar lecture series is a discussion of all codal provisions and latest jurisprudence as decided by the Supreme Court. This presented to you by Central Books in partnership with Philippine Association of Law Schools or PALS. For the pre-week bar lecture series, we still have civil law, labor law, criminal law, taxation law, remedial law. So kindly follow our page, Central Books, PH, and Philippine Association of Law Schools, showing in your screens to be updated with the dates and latest updates. We also would like to recognize our sponsor, Central Book. Without further ado, I am honored to introduce our esteemed lecturer. She is an accomplished author and currently serves as a presiding judge of RTC Branch 21 in Timos City, the designated commercial court for the province of Cavite. Before her appointment to the judiciary, she served as a senior assistant city prosecutor of Manila for 10 years. She has been a dedicated commercial law professor since 2003 and is a respected bar reviewer at institutions such as San Sebastian College, Recoletos, Polytechnic University of the Philippines, University of the East, Tarlac State University, Lyceum of the Philippines University, Philippine Christian University, Recoletos Cebu, Villasis Review Center, Academicus Review Center Incorporated, Albano Review Center, and Jurist Review Center. A proud alumna of San Sebastian College, she was recognized as Outstanding Alumnus in 2013 and as an Outstanding Prosecutor by the City of Manila in 2016. She has published several works with Central Books, including a Law Student Bar Reviewees, Handbook in Insurance Law, Negotiable Instruments in a Nutshell, Intellectual Property Code Simplified, Primer on the Revised Corporation Code, Corporation and Basic Securities Law, Reviewer in Commercial Law Volume 1, and the Annual Pre-Week in Commercial Law. Her article titled Disneyfication vis-a-vis Copyright Original Stories last was published in 2016 and again in the August 2019 issue of Enishi, a magazine by the Japan Patent Office. She represented the Philippine in Japan Patent Office and was the only Filipino participant in the colloquium for the teachers of intellectual property law held in Geneva, Switzerland in 2023. Please join me in welcoming the Honorable Judge Rocille S. Aquino-Tambasacan.
Okay, thank you for the kind words. Considering that this will be a marathon discussion, I decided only to highlight particular points. Hindi naman natin kayang masakop ang lahat. So what we'll discuss are only things which I believe are a good probable source of this year's bar examination. My lecture for today will be focused on 4 core subjects. So business organization, particularly corpo and partnership, insurance, and intellectual property. Okay. So, lagi naman akong may patalastas na hindi nawawala. Kung inabutan yung teletambi at wala pa kayong jowa, panis na kayo ngayon. So, I have these books with Central. And I'm promoting currently my pre-week, which is available already. You can buy it in store or you can buy it online. It costs 980 pesos. Don't worry, hindi kayo aantukin sa material kong ito. Okay? So let's go to corporation per se. The definition of corporation is found in section 1. But you see, there is no bar examination telling you define what a corporation is. No, walang ganun. So let's look at the definition under section 1. Artificial being created by operation of law, having the rights of succession and the powers, attributes, and properties expressly authorized by law or incident to existence. So from this definition, you see the 4 attributes. Ano yan? Artificial being, created by operation of law, the right of succession, and it has powers, attributes, and properties expressly authorized by law or incident to its existence. So, paano tinatanong ang artificial being concept? In consonance with separate juridical personality concept. So since the corporation is an artificial being, it has a personality, separate and distinct from the persons behind that corporation. So these stockholders' personality is separate from the corporation. However, the law admits of an exception, piercing the veil of corporate fiction. Since stockholders enjoy limited liability concept, the debt of the stockholder is not the debt of the corporation and vice versa. Paano nga pala tinatanong ang separate juridical personality concept sa bar in the past? Like, the BIR is collecting for unpaid taxes of the corporation. Hindi nagbayad ang corporation. Can the BIR immediately go after the stockholders? So the answer is of course no, because of the separate juridical personality concept. But this can be used as a shield for abuses. That is why you have piercing the veil of corporate fiction. How would you pierce the veil? You file a case in court, impleading the stockholders as well as the corporation. Because if you file a suit against the corporation only or against the stockholders only, you are respecting the separate juridical personality of each. So you file a case in court dual. And under what circumstances will you pierce it? So we have this old definition. Alam ko may bagong definition na fraud, alter ego, equity cases, but that is, I will still, as professors, find the old definition better. When the corporate fiction is used to do what? Defeat public convenience, justify wrong, protect fraud, defend crime. When it is made as a shield to confuse legitimate issues, or when it is a mere alter ego or business conduit of a person, or when the corporation is organized in such a manner as it is just an instrumentality of other corporation, then the veil separating the corporation from the stockholder will be lifted and set aside, and they will only be considered as an aggregate of individuals. I borrowed this picture from the website kasi maganda naman ang pagkakapicture niya. The one who is indebted is the corporation, but the corporation has no money. That is why the creditor is going after the stockholder behind the corporation because they only use the corporation as an excuse, as a shield to avoid liability. Okay. What if there is a parent-subsidiary relationship? Kasi the subsidiary is owned by the parent. Mere ownership is not enough. We have to look at these elements, the element of control. What kind of control? Not mere stock control, but complete domination. Not only of finances, but of policy and business practices, so that the entity has no separate mind and will of its own. And this control must be used to commit a fraud, perpetuate violation of any legal duty, and must be the proximate cause of the loss. Let us take recent cases illustrating piercing the veil, and if there's a need to pierce the veil. In the case of the Solgon, they are employees of CyberOne Australia. But CyberOne Australia later on decided to have CyberOne Philippines. So CyberOne Philippines was incorporated with these employees becoming incorporators and managers. But CyberOne Philippines proved to be unprofitable. So CyberOne Philippines had to close shop. And these people were dismissed. So they're asking for payment of their separation pay from CyberOne Australia. So is there a need to pierce the veil of corporate fiction? Well, from the facts I gave, there is no showing that CyberOne Philippines was organized for the purpose of defeating public convenience, perpetrating fraud, avoiding existing obligation. It was not the purpose. So just because the stockholders of CyberOne Australia and Philippines are common is not a reason to automatically pierce the veil if there are no other circumstances showing the need. There is also no proof that Australia has absolute control over Philippines. In another case, in the case of Linden Suites, Linden would like to examine the officers of Meridian in order to know if their income and assets are sufficient to satisfy the liability of Meridian because they are collecting after Meridian. But this could not be done. Why? because the reason for examination is not for the purpose of passing the liability of Meridian. It was not a word in the motion. The only objective is to know if these respondents would have, if the income and properties can be subjected for execution in order to satisfy the final judgment on the part of the officers, nothing else. This is the first Justice Javier case I'll be discussing on piercing the veil. HSBC has an employee, Galang, and HSBC offers housing loan to employees through another entity, HSBC Limited Staff Retirement Plan. So the property was mortgaged to the staff retirement plan in exchange for the loan. But Galang was dismissed from employment. Unfortunately, the retirement plan has a requirement that if you are terminated from HSBC, you are required to pay the full amount. So what Galang did is to sue HSBC and SRP. Even though HSBC is not a signatory to this mortgage agreement, the argument is that the interest now of HSBC is intertwined with that of SRP because there's a requirement that the employees must be an employee. Otherwise, the whole amount will be demandable. So is this correct? The Supreme Court recognized the separate personality of the subsidiary, the SRP, HSBC SRP, from HSBC per se. And it was not shown that SRP was made in order to commit a fraud, perpetrate a fraud, or avoid existing obligation. The only argument is that there was bad faith because there was foreclosure of the property. The insistence that the interest of HSBC is intertwined with that of HSBC SRP is actually a collateral attack and cannot be done. No, because the only one who can do that is the OSG via a co-warranto proceeding. Okay? So take note of this first Justice Javier ruling. Can we reverse? Kasi kanina, piercing the veil. Can we reverse pierce naman? In reverse piercing, the person wants to go after the asset corporation because the one who's liable is a corporate insider. So it can either be outside or inside. Outside if it is a creditor who goes after the corporation because the one who's liable there is the individual stockholder. In inside reverse piercing naman, it's the controlling members who would like to ignore the corporate fiction. They want to make use of the advantage available to the corporation for themselves. So going back to the picture earlier na may nakopy ako sa internet, ito naman yung picture ng reverse piercing. So the creditors going after the money of the corporation when the person indebted has no money. There's only one landmark case on reverse piercing. The case of International Academy versus Liton. Anong story nito? Si Attorney Santos ay lessee ni Liton at hindi siya nagbayad kaya a case for lawful detainer was filed. Attorney Santos lost. He was directed to pay. That is why the sheriff levied on a property which is the name of International Academy. And Santos is the president. So this is a property in the name of International Academy. How come the sheriff is levying over it when the one who is indebted is Attorney Santos, not International Academy? It's because Attorney Santos makes himself or presenting himself to be the alter ego of International Academy. Why? The lot was bought during the time that there is no International Academy yet. However, Attorney Santos had represented himself to be the president of International Academy. Wala pa namang ganong eskwelahan. Wala pa namang ganong enterprise. Therefore, he is making it appear that he and International Academy are just one and the same. Now, sa topic naman ng class of corporation, what I find important is about stock and non-stock. Why? Because I have another Justice Lazaro Javier ruling. Stock corporations are those which are divided into shares, number of shares, and are authorized to distribute dividends. In non-stock, there is no income which is distributable as dividends, but it does not mean naman non-stock cannot earn income. It can earn income. but it's being flowed back to capital. Capital is not being distributed. In the case of NFA versus City Government Tagum, a Justice Javier ruling, NFA is organized with a capital stock of 5 billion divided into 50 million shares with par value of 100 each, and all of the shares are owned by the national government and local government. So what is the job of the NFA? To oversee the rice inventory in the Philippines. NFA has properties in Tagum City and the local government would like to tax it. Pero argument ng NFA ay hindi dapat tax because we are a GOCs. We are not a GOCC. We are an instrumentality of the government. So is NFA a GOCC or not? NFA is a government instrumentality. Hence, it is exempt from payment of taxes. How about the fact that it was organized as a corporation with billions of capital and with stockholders? Although it has capitalization divided into shares of stock, these are owned by the government. It has no stockholders or voting shares. There's even no distribution of dividends. If there's income, the income is being controlled by the president in accordance with the fund requirements of the NFA. Therefore, it is not a stock corporation. It cannot also be a non-stock because it has no members. Even if we say that the government is the only member, there is no, it is still a non-stock because non-stock cannot distribute income to its members. But in this case, the income are controlled by the president in accordance with the fund requirements of the NFA. So it is not a stock nor a non-stock, but not a GOCC, but a government instrumentality. Now, for nationality of the corporation, we have the place of incorporation test. That is the test to determine whether the corporation is domestic or foreign. And we have another test, which is the control test or the grandfather and the grandfather rule. What test do we normally apply? If the first test is the test on whether the corporation is domestic or foreign, because if the foreign corporation will be engaging in business, it is required to get a license. That is why we have to know if it is domestic or foreign, because licensing is not required for domestic. But control test is mandated if the entity will be engaged in a nationalized industry. Ano ba yung nationalized industry? So under the Constitution, under special laws, for the Constitution, educational, exploration, development, utilization of natural resources, mass media, public utility. So these are required to be in the hands of Filipinos, meaning 60% Filipinos. So if the control test was complied with, does it mean that there's no need to use the grandfather rule? When there's doubt on who really has the beneficial ownership and control of a corporation, the more stringent rule, the grandfather rule, will be applied where there's doubt. Ano ba yung grandfather rule? It is the method by which the percentage of Filipino equity in a nationalized or partly nationalized industry is computed, where you look at the nationality of the second or even subsequent tier of ownership, determine whether that is a Filipino. So example, Corporation C is engaged in nationalized industry. So you have to look at who owns it. Nakita mo si B and si Y. B is 60%. So following control test, tapos na, di ba? However, when there's doubt on who owns B, that is where you dig deeper. You found out that it's owned by A and owned by X. And A actually pala is a foreigner. So, following grandfather rule, there will be a violation. To arrive, you have to, at the actual Filipino ownership, you combine direct and indirect shareholdings. Why do you have to combine? Kasi the same thing is arrived at. You would have control either directly acquired or indirectly acquired. E paano kung maraming levels, corporate layering, multi-tiered corporation? The rule is, stock attribution must be allowed to run continuously along the chain of ownership until it finally reaches the individual stockholders. So parang walang specific point na titigil ka kasi you're required to run continuously along the chain of ownership. This is lifted from a BIR Memorandum Circular by Hanares, okay, which was cited in the case of Nara Nickel. So you would have to dig deeper. Up to when? Ay, wala yan. Walang sinasabi. Basta it's allowed to run continuously. It's like the proverbial rabbit hole in Alice in Wonderland. It never ends. So let's see at this Nara Nickel case. There is a mining company, Redmond, who would like to have to mine in Palawan, but when he went to DNR, he found out that there was already a mineral production share agreement with entities Nara, Tesoro, and MacArthur. So what Redmond did was to dig who owns Nara, Tesoro, and MacArthur, and looking at the financial statements. The three are actually controlled by a 100% Canadian corporation, MBI Resources. How was that seen? Okay. Ito yung sinasabi kong dig deeper. So they look at Nara. First glance at Nara, it's owned 60%, less than 59.97, owned by a domestic corporation. 39.98, MBMI is Canadian. See, all in the example you've seen, Nara, Tesoro, and MacArthur, MBMI owns the 39.99, talagang below 40%, right? So, there was a need, however, even if there is compliance with the Filipino ownership requirement, majority is Filipinos, they had to dig deeper on who owns Patricia Luis, who owns Sara May, who owns Madridejos, because there was doubt. Anong doubt? There is doubt on who has beneficial ownership and control of the corporation. How is it seen? The foreigners are the minority. They provide all of the funds, as well as technological support, as well as they managing the company, providing economic viability studies. So when they digged Patricia Luis, Sara May, as well as Madridejos, they have seen that there is an allegedly Filipino entity above 60%, Palawan Alpha South, Olympic Mines. But they did not contribute a single peso to the capitalization. In short, what they own is percentage of ownership in stocks, but they did not pay a single peso. Therefore, it is the minority, Patricia Luis, Sara May, and Madridejos, the MBMI Resources, the minority, which is the one controlling or running the corporation. Why? Kasi they provide the foreigners, even if they're the minority, are the one who provide all the funds, all the technological support. And they're the ones who manage the company because the Filipinos are just owner in paper. So here, the contract was invalidated as a result. Now, for the doctrine of equality of shares, it was said that all shares are equal with respect to every other share. But there are some shares which are not equal from the very beginning, like voting and non-voting. Kasi common shares are the ones who normally vote. Those who do not vote are preferred shares or sometimes redeemable shares because these are provided for in the corporation if they would have non-voting preferred. But it does not mean that just because you are not voting, you cannot automatically vote. Okay, let's take this scenario because this is also asked in the bar. You are a non-voting preferred stockholder. And there was a meeting of the stockholders where the name of the corporation will be changed and the corporation will be engaged in a line of business. Say, you are Jollibee Foods Corporation, Jollibee Funeral Parlor. Oh, two actions. First, can you vote in the change in the name? A change in the name is an amendment. So you are non-voting, you can vote. How about Jollibee Funeral Services? That is investment in another corporation. Again, you can vote. But what if the meeting is for the election of the board of directors? It is not found here that non-voting you can vote. Therefore, only common will be the ones who will vote. Now, let's go now to the incorporators. this was already changed under the law because it used to be that a corporation cannot create another corporation. But this was changed because now a corporation can form a corporation also with someone else. And also, there's a concept of OPC, one person corporation, whereas only a single stockholder will be in the picture. For incorporators, the requirement is being a natural person. Ano pang nabago sa corporation code? It's a term. Because corporations now can exist forever. It's automatically perpetual. Question: what if the corporation was organized under the old law? Does it mean that its term is only that appearing in its articles, which is 50 maximum? The answer is no. Automatically, those pre-existing corporations would have perpetual existence. The only requirement is if the descending stockholders wouldn't agree, they would have to exercise their appraisal right. But it is presumed that pre-existing corporations will have perpetual existence. There is no action on the part of the corporation to have it amended because it's by operation of law that if you're pre-existing, you're automatically perpetual. Exception would be if you make use of the perpetual existence. So subject also to extension or shortening of the term. The law also now allows revival, but there are requirements for revival, one of which is if you are one of those entities regulated by, say, Insurance Commission or the Bangko Sentral, favor recommendation of these institutions must also be procured. And if there is a violation of the law under Memorandum Circular, then that corporation cannot ask for revival under the law. There's no more minimum capital stock. In the old law kasi merong minimum, ngayon wala. But can a corporation exist with just 10 pesos? The answer is yes, because there's a distinction between the right to incorporate and the ability to operate. That is why the concept of delinquent corporations had come in. Because if the corporation is unable to run business because it has small capitalization, then that will be a ground to put the corporation under delinquent status. But nonetheless, the corporation can be incorporated even with 10 pesos. The doctrine of apparent authority is an important doctrine here kasi meron tayong recent Supreme Court cases on this. It's also known as the holding out theory or the doctrine of ostensible agency. So the corporation will be stopped from denying the authority of the agent if it knowingly permits its officers to act within the scope of apparent authority. And how will you know apparent authority? It can be seen in the manner which the corporation holds out the officer as having the power to act or its approval with certain acts. So let's take cases illustrating how it was held up or held to the public. In the Allied Bank case, the branch manager had been giving a credit line to a valued client. So when an expected deposit would be coming in, the branch manager did not wait for the deposit before transferring the money to 5 different accounts. So the money did not come in. So the question is, considering that the branch manager already transferred the money to different accounts, can the bank be held liable? The answer is yes. Why? Apparent authority. How was it seen? From the prior acts. Because that branch manager in the past had given or had approved a temporary overdraft line to this valued client, Helen. So we see it from the actuations. Another proof of apparent authority that there was exercise would be acquiescence of particular acts, like acceptance of benefits. In agro-food processing versus Vitarich, the parties had executed a MOA. So, pursuant to the terms and conditions of the MOA, they have to buy a dressing plant for chicken, and there would be an agreement to dress the chicken for a toll fee. But there were changes in these agreements, and the changes are only verbal, not in writing. And what was implemented were this verbal agreement. 2 years passed. Suddenly, Vitarich lodged a complaint for damages because there was we did not implement the toll fee agreement under the original toll agreement, but the verbal agreement. So, are the parties then been bound by the verbal agreement by the managers but when there's no authority from the board? The answer is yes. First, apparent authority. Why? 2 years, 89 billings, 3 amendments. There was never any contest. And the most important part is that there was acceptance of benefits because there was a price change. The price went up pursuant to the verbal agreement. And there was acceptance of benefits because there was increase in the profits. So, as apparent authority, as seen here, not only through the actuation of the manager, but the acceptance of or acquiescence of his acts seen by the acceptance of benefits, making the entity then liable. Another important concept is the doctrine of corporate opportunity. Why? Because we have a landmark case now explaining the application of this doctrine. It says that if there is a business opportunity where the corporation is financially able to undertake in the line of business, the corporate officer is not supposed to take it for himself. That is why if he takes it for himself, it should be accounted for the corporation. This doctrine has a biblical basis. Matthew chapter 6, verse 24. A man cannot serve two masters at the same time. The basis also under the code is sections 31 and 33 about this loyalty of directors, trustees, or officers. But if there is acquisition of business opportunity on the part of a director, the law allows ratification, but not for officers. There's no ratification. So let's take the case of Chang because this is the landmark case on the doctrine. So Chang is the president and GM of Tapros, owned by the T family. And Tapros is engaged in office supplies and equipment distribution. Chang was allowed by the T family to incorporate 3 corporations which are engaged in the same line of business, Identic, Golden, Exhibit, Top Gold. So ending, the business of Tapros went down because the sales went to these 3 corporations. When sued, the argument of Chang is that pinayagan naman daw siya ng T family. So does it mean that Chang is absolved from liability? Let's jump first to that argument. The answer is no. Knowledge is not enough. Why? Because the law says there should be ratification by 2/3 of the stockholders. Here, there was no ratification. It was only by inaction. And when the law says ratification, then that must be complied. Hindi pwedeng acquiescence yung inaction. What are then the elements of this doctrine? First would be financial ability to exploit opportunity within the same line of business. The corporation has an interest, and when he took it first as their own, the director trustee will be placed in a position inimical to his duties. In order to know whether it's a line of business, we have to look if they are in competition, meaning same line of business, same products, overlapping market, same business. The case of Tapros is a no-brainer because they are all engaged in the same line of business because they are all office equipment and supplies distribution. But what if I change the problem, like the corporation is engaged in a fast food business, and what will be opened up is a fast food business as well by that director, but the fast food business is not in Metro Manila, but in Mindanao. Will there be a violation? The definition says financially able to exploit. So even if it's in Mindanao, but there's proof that the corporation can expand to Mindanao, then there could be a violation of this doctrine. But if it is shown that the corporation cannot expand to Mindanao, then there's no violation. Also, what if the business is fast food and then the director's business is fine dining? Will there be an overlapping market? The answer is no. Why? Because the market of the one selling fast food is not the same market in fine dining who's willing to pay a 1,000 peso plate. They are in the same line of business, which is food, but they do not have overlapping markets. That's how this could be asked in another way. Now, for liability of the board of directors, we follow the business judgment rule. So questions of policy and management are left to the decision of the officers and directors, and the court cannot step into the shoes of the board unless it is attended with bad faith. Therefore, only if there is gross negligence that court intervention can be sought. Why? Courts are not in the business of conducting business. So pursuant to the free enterprise system laissez-faire doctrine, the courts will not interfere with making business decisions. So under what circumstances can the board of directors or trustees or officers be held personally liable for corporate obligations? First is that there must be bad faith, gross negligence. Mere ordinary negligence is not enough. It must be gross in character. And of course, there must be proof of bad faith. And bad faith is not presumed. It means dishonest purpose, breach of a known duty. So there is fraud present. In the case of Olivares was sued together with the corporation because there was non-payment of the commission of the agents. There should be no solidarity liability because there is no showing that it was made with fraud. There was no bad faith proven. The only thing that was proven is that the commissions were not paid. But that is not enough because there's no proof that it was made with bad faith. Anong instances ba na solidarity liability to attach? So, aside from gross negligence or bad faith, issuance of watered stock. What is watered stock? Issuance of stock below par value. So, par value 1 peso, hindi pwedeng 75 cents. Or, by express stipulation, the director or trustee had agreed to hold himself liable. What's also being asked in the bar is the powers being exercised. Pero, may kakambal to. Hindi lang exercise ng power, kundi is their appraisal right. Appraisal right is the right of the stockholder who dissents to be paid the fair value of his shares. So first would be extension or shortening in term, which requires board majority plus 2/3 of the stockholders. Appraisal right is present because there's a change in the primary contract with the corporation. So if the term is shortened from 50 to 30, the stockholder's right is impaired to receive further dividends from the 31st to the 50th year. If we reverse, the term is extended from 50 to perpetual, the right of the stockholder as well to the proportionate share of the assets in dissolution of corporation will be impaired kasi he will not receive it because the corporation will be living forever. That is why he is allowed a right to exit the corporation at that stage. So extend, shorten the term, increase, decrease capital, stock, and bonds have the same voting requirement, but this time, there's no appraisal right. Why? First is because there is a remedy provided before by law so that your percentage of ownership will not change with as capital stock is increased. Anong tawag doon? The preemptive right. And number two, even if you don't have funds, therefore you cannot exercise preemptive right, the corporation would be issuing stocks because it needs money, issuing bonds because it needs money. Therefore, if you will just use the money generated from the sale of stocks, sale of bonds, to pay off a stockholder who dissented, bakit pa tayo nag-issue ng stocks and bonds? Diba? It's rendered nugatory. So, logic ang dahilan. Is it subject to the SEC's decision when the capital stock is increased? If there's compliance with the requirement, the SEC's job is purely ministerial. It's administrative to approve, pursuant to business judgment rule. The second question, the wisdom behind for the issuance of additional capital stock as long as there is required compliance with the required documentation. Another right would be the right, the power to deny preemptive right. General rule, in order for you to maintain your percentage of stock holdings, you exercise the stockholder preemptive right, right? But this right can be denied by the corporation as long as, ito na, provided that preemptive right will not extend to shares to be issued in compliance with law requiring stock offerings or minimum stock ownership by the public, or it's issued in good faith with approval of the stockholders representing 2/3 of the outstanding capital stock in exchange for property need for corporate purposes or in payment of previously contracted debt. So if this is the reason behind why you are not allowed to subscribe shares, because there's a law requiring minimum stock ownership of the public, or it's to be issued in exchange for property, then the right to acquire additional shares will be denied. When we say shares of or stocks, it would be regardless of the kind of shares. It could have been an increase in the authorized capital stock or a disposition of the treasury shares. So all of these are covered. Power to sell or dispose assets. This is where the nil doctrine will come in. Same votation requirement. Mamaya nil doctrine will come in ahead. Dito muna tayo sa requirement. If it is in the usual regular course of business, then you don't need stockholder action or the proceeds is to be appropriated for the conduct of the remaining business. Let's take an example. The business is a hotel, and the hotel is hotel's transportation department is lugi. So they decided to close the transportation department, infusing the proceeds of the sale of the car to the linen section. Can that be done? The answer is yes. You don't need stockholder action kasi appropriated for the conduct of the remaining business. Or if the main business is a subdivision developer selling subdivision units. So if it is sell units, even if it sells 99% of them, you don't need stockholder action because that is in the regular course of business. And how will you know that if it involves all or substantially all? We have a computation, net asset value, or if the corporation is rendered incapable of continuing the business or accomplishing the purpose for which it was incorporated. What if it is a bus company and what was sold off are its buses? Siyempre, how can a bus operate without buses? So that is all or substantially all. But what if what is sold off is the repairs department? A bus company can still run even if it has no repair section because it can be outsourced. So it is not all or substantially all. I mentioned earlier the nil doctrine. What this was asked already in the bar. Anong kwento ng nil doctrine? It says that transfer of assets to another will not render the transferee liable for the indebtedness of the transferor, except in 4 cases. So there is an assumption, agreement to assume the debts, or that's a consolidation or a merger, or done for purpose of fraud, or it is merely a continuation of the selling. The Y.I. Leisure case is an example of the third and the fourth. Bakit? Si James Yu bumili ng country club shares and this Mount Arayat did not fully engage in business because it closed down. Its land was sold or transferred to yachts, Y.I. Leisure, and Y.I. Club. So James Yu is going after his investment. Can he do that? Is the transfer in one pursuant to the nil doctrine? Under the third and fourth one, yes. Why? Because it was made for purpose of fraud. And number 4, and that's the fourth one, you see, Y.I. Leisure is only continuing the business of Mount Arayat because they are still engaged in the same life business. So these are real estate, leisure, tourism, and all related projects. So you see here from the slide the discussion regarding Y.I. Leisure. What if there's an agreement between the transferor and the transferee? Well, the transferee will not be held liable for the indebtedness of the transferor. This agreement is only binding among them. It does not bind third persons. Therefore, the creditor can go after the transferee, but the transferee has a right of recourse to go after the transferor pursuant to the contractual stipulation. What else? The power to acquire own shares. What do we call those shares? We call it treasury shares. And why will shares be bought back when it is illogical? A corporation will be selling shares. Why will it buy its own? because it wants to do these things to remove fractional shares because of stock dividends, or to collect or compromise indebtedness, like a subscriber who did not pay his subscription, there will be delinquency sale, or a stockholder exercises appraisal right. So there's a need to buy back these shares. But there is a requirement. Ano yun? URE. There must be unrestricted rated earnings, because if there's none, it will violate the trust fund doctrine. The trust fund doctrine says the capital stock property of the corporation are equity in trust for the payment of the creditors, because the creditors are preferred in distribution. The creditors will assume that the board will not use the assets of the corporation just to buy its own stock as long as corporation has outstanding debts. So if there is an indebtedness to a creditor, that must be paid off first before there can be distribution of assets to stockholders. So another would be investment, but if that is the primary, only majority board approval is concerned. Like the business is an investment firm. If it invests, then that is its main job. You don't need stockholder action, only board. But if that is not its main job, it's another purpose, even secondary, you need stockholder action. The power to declare dividends. Is dividends the same as income or profits? The profits pertain to the corporation. Dividends pertain to the stockholder, because it is possible that there are profits but there are no dividends, because this is subjected to the wisdom of the corporation. This is judgment rule. What is the voting requirement? For cash dividend, only board approval, but for stock, 2/3. Why is it that stock dividend requires stockholder approval? Because stockholders are deprived to participate in current profits. That is why they need stockholder approval in that case. Stock corporations cannot withhold surplus profits up to a certain sum. Example, the corporation earned 1 million, but the corporation's paid up capital is 3 million. So, pwede bang hindi mag-declare ng dividends? Yes, because it is below the threshold. The requirement is if it will be more than 100%. So, if the corporation, halimbawa, has a paid-in capital of 3 million and it earns 10 million, o di lampas-lampas na sa 100%. So, is the corporation mandated to issue dividends? General rule, yes. Exception, these three. There is a corporate expansion project. Natanong na ito sa bar, lahat ng exceptions ha. Prohibited under loan agreement, that you must get first the consent of the creditor. And number 3, the retention is necessary as reserve for probable contingencies. Like in a bar in the past, ang tanong ay, there is the stock market crash or the Asian financial crisis. These are justifiable. So ngayon, paano kung COVID pandemic? Pwede rin gawin ng excuse. I said earlier that the source of dividends must be URE. There must be unrestricted retained earnings. Is it possible that you can declare dividends coming from an increase in the value of an asset? Say, if the land is formerly 1 million in the books, but now the market value is 5 million, can there be dividends for the 4 million? The answer is no, because the sale is not yet realized. That could be a possible source if it was realized. But since it is just a book increase the value based on the books, there's no realization yet. There is no dividends. Another thing to remember is that if the dividend is in the form of stock dividend, another source is not only unrestricted retained earnings, but paid in capital or paid in surplus. Entering into management contracts has never been asked in the bar, but you see here in the slide regarding the voting requirement as well as the ratification rule. So if what is to be exercised is not one of those listed earlier, not expressly provided for, then that is considered to be ultra vires, meaning entered into beyond the powers. But does it mean that because it is ultra vires, the act is the act is void? Well, there's a difference between illegal and ultra vires. Because illegal acts are not subject to ratification. Those which are ultra vires can be ratified, like is corporate officer who enters into contract without board resolution empowering him to do so. So these are cases illustrating ultra vires act, but this some can be ratified here because it's exercised only beyond the powers, but others are not because the corporation is not empowered to do it in the first place, like allowing a property to be mortgaged when it is a school and it's not within the powers of the school to mortgage. But the privation of a delinquent member use of the facilities because it is delinquent would be a valid exercise on the part of the corporation. Now, ano tong trust fund doctrine naman? So, we'll zero in on doctrine. Under the trust fund doctrine, which I've said earlier, there should be no distribution of assets without first paying corporate indebtedness. E paano kung ang nangyari ay a subscribe to a certain number of shares and then hindi makapagbayad? Can it just be converted into treasury shares? That will violate trust fund doctrine. That's the case of Salido. So in this case, when there is non-payment of the subscription, what is the remedy? It is not via treasury shares. It is via delinquency sale. The stocks will be declared delinquent so that it can be sold off to pay the obligation, but not via reclassification into treasury shares because it will violate trust fund doctrine, there being no available assets. Okay, so we're now with indivisibility of subscription. What does it mean? A certificate of stock is issued only if everything had been paid. That is why if you bought or subscribed 100 shares of stock and paid only 50 pesos kasi 1 peso per share, so technically that's 100 pesos, you paid only 50 pesos. Are you entitled to stock certificate for 50 shares? That was asked also in the bar. The answer is no, kasi nga indivisibility. It means if you made a partial payment, the partial payment does not correspond to any particular share. It corresponded to the entirety of the shares. So if you paid 50 pesos, it means you only paid 50 centavos for share 1, share 2 to share 100. Okay. Now let's go now to the rights of a stockholder, particularly the right to inspection. This right to inspection is afforded to all stockholders of record, except, of course, if you are a competitor, director or officer of a competitor, you have no right to inspect. What if you are allegedly now a competitor and it was not proven yet? The corporation filed a TRO, an injunction to prevent you from examining. Can the corporation do that? The answer is no. Injunction is not an available remedy. So what should be done if you are really a competitor? Then the corporation should disallow examination. And if the corporation is later on sued for for refusal to examine, the corporation can raise by way of defense the argument that you are a competitor. But the corporation cannot use strike first. The corporation can only use it as a shield. Kaya hindi pwede ang injunction or TRO to prevent inspection. What if your father is the stockholder and your father dies? Does it mean that you also would possess the right to examine, being transferred to the heirs? That the examination cannot be done by the heir. Following the Puno doctrine, the heirs will not automatically become stockholders because the estate must be dissolved first, or the assets of the father should be liquidated, and it will be ascertained whether or not there will be assets remaining so that the heir can say that there is something remaining with the estate. So in the meantime, since there's no settlement of the estate, what will happen? The right to examine will be lodged with the administrator of the estate or executor of the will, not to a particular heir. Okay, if the corporation would refuse examination, the director, trustee officer, particularly the corporate secretary, should be the one to be held liable for damages. What defenses can the corporation raise aside from being a competitor? Remember the Gokongwei case where Gokongwei is connected with CFC Robina, and he is a member of the board of directors in San Miguel. And the bylaws has now a provision prohibiting competitors from being directors. Therefore, they can also not examine. That is the rule. So, aside from being a competitor, what else? Not acting in good faith or improper use in the past. What if the stockholder is stockholder in the past of Corporation X, and he used information obtained in Corporation X? 10 years later, he becomes a stockholder of Corporation Y, and likewise requests to examine corporate records. Can the Corporation Y use the actuation of that stockholder in Corporate X? Because the law says prior or any other prior examination of such corporation or any other corporation. So even if the corporation is different, it only shows habituality. Kaya he will be disallowed to examine. What if you only own one share of stock and the corporation has 10 million shares, all issued and outstanding? Again, the law does not say any numerical quantity for examination. Because when the right is granted to all, there's no distinction whether that is one share or only a majority. What if the corporation says, hindi naman kami engaged sa illegality. We are not mismanaging shares. Well, that is not the only reason why a stockholder will examine records. It's only not mismanagement. It can also be for assessing the financial condition, or to look at the value of the shares because they plan to sell it, or they want to get a list of stockholders for proxy, or they want to get information in aid of litigation. All of these instances, I have already cases decided where all of this happened. But most of the time, the argument for examination is mismanagement. So, in contrast, the proper purposes would be to get trade secrets, business secrets, or business prospects, or to find technical defects because they want to employ a strike suit. Now, for merger and consolidation, there is a technical definition for merger and consolidation. Because in merger, one absorbs one or more, and the absorbing corporation survives. That is why in math, I use this as A plus B equals A or B. Okay? Because any one of them would survive. In consolidation, two or more would combine to form a new one. We call that the consolidated. So A plus B equals C. There is a new entity. However, whether that is a merger or consolidation, they have the same effect. What is that effect? Automatically, all the assets and liabilities of these corporations, constituent corporations, are absorbed. So there is no liquidation or winding up requirement because the corporation, through the consolidated corporation or through the surviving corporation, would continue. Okay? What if there is no formal compliance with the procedure regarding merger or consolidation? Can there be still a merger? Yes, that is what we call de facto merger. Because when one corporation would buy all the properties of another in exchange for shares of stock of the acquiring would end up with everything, the business enterprise of the target. The target, on the other hand, would have only shares of stock. But this doctrine, de facto merger, although there was an explanation, in the case of in the Bank of Commerce case, there is no de facto merger because there is acquisition only of specific assets and liabilities. So not everything was bought. So I said earlier that insofar as the effect, they are the same because everything is absorbed, meaning all the assets, all the liabilities. And what if the creditor would complain? Can the creditor complain? It does not want to go through merger or consolidation? The answer is no. The creditor has no right. Why? Because everything anyway survives. So liabilities will survive. There is the case of Philippine Geothermal, where the employees of the considered corporations ask for payment of their separation pay. Bakit? Kasi sabi nila, ay, nag-merger, wala na yung Chevron, sarado na yung Chevron. Therefore, we're entitled to our separation pay because we are dismissed. Is that correct? I said all of the assets and liabilities are absorbed. When we look at labor employment contracts, it could either be they are considered assets in the eyes of labor law, or they can be liabilities in the eyes of commercial law. But any way you look at it, they're still considered absorbed. All assets and liabilities, including employment contracts, are absorbed. Therefore, they are not entitled separation pay because they are not dismissed. Pero they were later on dismissed because of redundancy. However, the cause of the removal is under the labor code, redundancy, not pursuant to merger or consolidation. Pero kung i-analyze nyo, di ba, approximate cost pa rin naman yan in merger or consolidation kasi kung hindi sila nag-merge, edi sana hindi nagka-doble-doble yung mga branches at hindi kailangan magsarado. But anyway, this is how the Supreme Court analyzed it. And there is a new case where one of the corporations had merged with another. And then, since the constituent corporations are already gone, the surviving corporation said, I should step into the shoes of the constituent corporation, which has a case pending with BIR for tax refund. The BIR, however, said, wala na yung corporation, therefore wala na rin tax refund. But I said earlier, but when there's a merger consolidation, everything is absorbed, including the right to recover for excess taxes paid. So the posture of the BIR is incorrect. Now, appraisal right is the right to be paid the fair value of shares if you, as a stockholder, would dissent for any corporate act. Appraisal right is not automatic. I have an acronym ATSIM. Exercise of appraisal right is only for amendment of the articles, which is the effect of changing the rights of a substantial right of a stockholder, like changing the term, sale, lease, exchange, mortgage, pledge of all substantial of corporate assets, investment, and merger or consolidation. So, ATSIM. Paano kung ang example ay the name of the corporation was changed? Will there be appraisal right? Porque ayaw mo ng fuchsia at gusto mo pangalan na Blue Corporation? No. Because the change in the name did not change any right of the stockholder. But if what was changed, halimbawa, is the kind of shares, dati common stockholders lang meron. The articles were amended, meron na ngayong preferred shares. Therefore, if you are a common stockholder, your right then is impaired. Okay? So take note, kasi dyan nagtatanong sa bar, hindi enumeration kundi kwento, tapos isipin nyo, ang kwento ba ay nakasaksak doon sa enumeration? Okay. So sa closed corporation, ang importante dito is how to become a closed corporation. It is not by the number only of ownership. You have to look at the restrictions. Because even if it is held by less than 20, but the stocks were later on publicly offered, then it's no longer a stock corporation, and it's no longer a closed corporation. It had become already a publicly listed corporation. Remember, Channel 2 Channel 7 in the past, it was formerly owned only by the Gozums. They are not more than 20. But since they decided to have it publicly offered, hindi na siya closed corporation. It's already a listed corporation. Also, is it possible that a corporation will remain a closed corporation even if there is a corporation owning that closed corporation? There is a maximum. If 2/3 of the voting stock, so 66.67%, is already owned by another corporation, it is not a closed corporation anymore. So, dapat below the 2/3 threshold. Closed corporations pwede kahit anong negosyo, except most BPEP. Mining, oil, stock, banks, insurance companies, public utilities, EDUC, and those vested with public interest. Merong unique about closed corporation. It is about deadlock. Under the trust fund doctrine, there should be no disbursements unless there is URE, disbursements to stockholders, unless there is unrestricted retained earnings. The exceptions are only two. Number one, redeemable shares kahit walang URE can be redeemed. And number two, when there is deadlock. In order to break the deadlock, there would be acquisition of shares. So even if there is no URE, that is feasible for deadlock purposes lang. Okay. Now, sa closed corporation naman, ang natatanong na dyan ay difference ng OPC from the traditional ordinary corporation that we know of. The one is insofar as officership is concerned. Because in ordinary corporation, hindi pwedeng President, Secretary, Treasurer at the same time because there will be conflict of interest. But in OPC, pwede ang the same president is the treasurer as long as there's a bond posted. But for president secretary, hindi pwede, not because of the possibility of abuse. It is because the secretary has a special role, which is to call for the nominee or alternate nominee when the sole stockholder dies. Siyempre, paano tatawagin kung siya na rin at the same time, hindi patay na siya? Paano sino magtatawag? Diba? So, the OPC was set up because there are persons who are looking for the separate juridical personality concept, but works like a sole proprietorship, and that is where OPC comes in because everything is owned by that single stockholder. That is why the procedures are different. Simpler, there's no board running, only you, the single stockholder. No recording to be kept, walang mga books, only minutes book. For meetings, only written resolution is required. You don't meet because who will you meet? Yourself, di ba? Parang katagagaguhan naman yun. So that's why we held an OPC. What if an OPC was established and the single stockholder dies? Does it mean that the employees can ask for payment of their separation pay because there's no more OPC? That is wrong. Because the OPC can still continue to exist even with the death of the stockholder because of the separate juridical personality concept. So what then will happen? The estate will step into the shoes of that single stockholder and will have a choice whether to continue the OPC being run by the estate or to convert it into a regular ordinary corporation or dissolve it. Now for dissolution, is dissolution the same as liquidation and winding up? No. This is actually stages. Dissolve, then liquidation and winding up, then termination. Dissolution means it ceased to exist as juridical person. It cannot continue transacting business. Pareho rin ito ng concept sa partnership. When there's dissolution, there's still a corporation, but that corporation cannot enter into contract for doing business. Ibig sabihin, it can enter contracts not for the conduct of business. For example, if the bank is dissolved, can the bank accept deposits? No. But if that bank is dissolved, does it mean that it cannot then enter into a security service for the guarding of the premises? Pwede pa a security service because it is not for the purpose of continuing business but for purpose of winding up affairs. Under the corporation code, there's only a 3-year winding up period. The winding up period is not the period to finish everything else. It's only the period given by law for the corporation to institute charges or to file cases or to transfer the reins from the old board to the new board. But it does not mean that everything will be done in the 3-year term. In banking law, the period is shorter. It's only 6 months. So, what if, when the corporation is dissolved, merong pending case for examination of records in the RTC? Does it mean that that pending case will be dissolved or dismissed as an effect because of the dissolution? That's the Aguirre case as in the bar. The answer is no. The parties remain to be corporate actors. The relationships are not changed. They're still stockholders. But the right to examine would subsist even if there's already a liquidation. So the rights and the parties of the parties not impaired just because there is a dissolution. So maganda yung tanong yan. Plus yung sinabi ko kanina regarding collecting from BIR of unpaid taxes. Foreign corporations now. Foreign corporations, why do you have to know? Because if that foreign corporation will be engaging in business, there is the requirement that they must have a license to do business. So the foreign corporation must also follow reciprocity, where Filipinos are granted the same opportunity in their home country. So if that foreign corporation will be doing business, you need a license. Because if you do not have a license and you do business, you cannot sue, but you will be sued. Ano ba yung doing business? The corporation code did not define doing business. Because the test is if the foreign corporation continues the body of the or substance of the business or enterprise which is organized or it has retired from and turned to another, and there's a continuity of commercial dealings in progressive prosecution of the purpose of the organization. If the foreign corporation is only collecting for tax refund, does it need to get a license? Following the enumerations under the Foreign Investment Act, that is not doing business, because by express stipulation and under that law, it said that the phrase doing business will not include mere investment as a shareholder. So if you merely invest, that is not doing business even if you are deriving income. Okay? What if only one contract was entered? So is the continuity not complied with? This is the case of Magna Ready Mix Concrete, the landmark case on this. Because Andersen entered into only one contract with Magna, which is for development of a precast plant and double T design. Si Magna is tapador, hindi nagbayad kay Andersen. And then Magna says, "Uy, Andersen, you have no license to business, therefore you cannot sue." First is that it is a stop from denying the lack of legal capacity because Magna entered into contract. And number two, yes, Andersen is doing business even if there was just only one contract entered into. Why? Because the contract was up in progressive pursuit of its business purpose, because the main job of Andersen is to provide consultation and design service. And that is the contract which is entered into with Magna. So even if it's only one, considering that is the main job of Andersen, then that is doing business. So you do not look at the numerical value, the thing, even if it's just one act. But that act is the act for which it was created, then that is doing business. There is a difference if it is alien, it is different or not related to the common business, then that would be an isolated transaction. Take note of this Magna Ready Mix because that is the landmark case on this. What if the foreign corporation enters a contract through a middleman? The one who's entering into contract, the one who's engaging business, is not the foreign corporation, but the middleman. Therefore, there is no need to get a license to do business. The doctrine in Development Bank versus Monsanto. Okay, so indentors are a synonym, what we use for middleman, because they do business in their own name, not in the name of that foreign corporation. In relation with foreign corporation, we discussed the Foreign Investment Act kasi kasama siya sa bar. May panahon kasing tinatanggal ito sa syllabus, meron ding dinadagdag. So ngayon, nakadagdag na naman siya. Anong tinanong sa Foreign Investment Act in the past? About the negative list. What is a negative list? It is a list of areas of economic activity where it is reserved, where there's only a 40% ownership for Filipinos, for foreigners. In short, equity 60%, must at least 60% must be owned by Filipinos. It is a list of business where foreigners cannot engage in. And we have to take a look at the 60-40 ratio again. Huwag niyong kalimutan yung kaninang pinagdadaldal ko na grandfather rule kasi mayroong relasyon din yan dito sa 60-40. So there are two kinds of lists. List A is reserved pursuant to constitutional specific laws. Example, mass media, public utility, exploration, development, utilization of natural resources under the Constitution to be owned by Filipinos. Now, there's another list, which is List B. These are defense-related, which requires clearance from the DND, as well as those which have implications on public health and morals. So, there is a provision also for micro and small domestic market enterprises with paid-in capital of less than 200,000. If it is less than 200,000, these are reserved to Filipinos. However, provided that they involve advanced technology, they are startup enablers, or majority of direct employees are Filipinos. But the Filipinos shall not be less than 15. Then the minimum paid-in capital can be lowered to 100,000 for non-Filipinos. Other than that, wala na akong naisip na tanong sa Foreign Investment Act kasi in the past ay application din ng Foreign Investment Negative List. Now, The last topic for corpo will be derivative suit. In derivative suit, mahilig siyang itanong in the form of what are the requisites of a derivative suit. So we have to take a look if the elements are present in the story. A person can be suing in his own capacity, or in representation of a certain class, or in representation of the corporation. So it all boils down on who is the injured party. Because if the corporation is the injured party, but of course, the corporation cannot sue by itself because it needs the board of directors. But the one who's committing the wrong is the board of directors. Eh, sino magdedemanda? That is why derivative suit comes into the picture. Because it recognizes that in cases that the wrongdoing is committed by the board, no one will sue in behalf of the corporation. This is impliedly recognized when the law makes directors, officers, liable for damages for violation of their fiduciary duties. Anong fiduciary duty? Obligation of loyalty, obligation of diligence. Okay? Now, there are requirements for a derivative suit to exist. These are under the rules of procedure for intra-corporate controversy. First, you must be stockholder at the time of the action and at the time the transaction happened. You must have exerted all reasonable efforts as alleged in the articles, bylaws. There is no appraisal right. The case is not a nuisance or harassment suit. And it must be brought in the name of the corporation because the aggrieved party is the corporation. There is a landmark case on this, Ago Realty, regarding the majority. So, story ng Ago Realty is that the sister, Angelita, who owns 30% of the shares, is the one running the corporation. The 70% owned by Emmanuel, the other brothers. Kanila 70%, pero hindi sila nag-run. Angelita introduced improvements to the property. So the 70% complained. That is why they filed a derivative suit. So the 70% are the majority. Can the majority file derivative suit? The answer is no. Why? Because the majority can simply oust the minority. Remember that derivative suit is a last-ditch effort. There's no other remedy available. That's why you made use of a derivative suit. Therefore, if there's a remedy, then that remedy must have been used. So, exhaustion of all remedies. Here, since they are the majority, they could have simply ousted the minority. But how come they did not oust the minority? Because they do not have a board of directors. Therefore, the proximate cause here is the failure to create a board of directors. If there is a board-sanctioned litigation, it takes precedence over derivative suits. But since this did not happen, the corporation cannot just simply use derivative suit as an excuse to oust the minority. So here, take note of this landmark case regarding the majority cannot institute derivative suit because there is a remedy provided for by them by law. The derivative suit cannot be used as a shortcut. E paano yung argument nila na they tried to talk out, so they tried to exhaust all remedies. They tried to talk out pero nag-exit naman yung kabila. Now, you cannot use that as an excuse because the one who sues must allege that all efforts should have been exhausted, which are provided for under the articles or bylaws. So, all redress available. So, if there is no failure to allege that everything had been addressed, then a derivative suit cannot prosper. Must it be proven? Okay, because the requirements is there must be exhaustion, there must be no appraisal right, and it must not be a nuisance or harassment suit. Must it be proven? The law only requires allegation. Derivative suit must allege that there is no appraisal right, that it is not a harassment suit. It is just a categorical statement. There is no requirement of proof at this juncture in the institution. So, lahat ng bar exam na may tanong on derivative suit, it's always about the application of the elements. So, I am reminding you to go back to the definition of the derivative suit as well as the elements. Yes, so now for partnerships, which we are discussing in conjunction with corpo kasi there are both organizational structures. Sa partnership kasi, konti lang ang tinatanong dito sa bar. And paulit-ulit, nakikita natin ano-ano mga topic na to. Okay, so you will not forget this. Kasi sa partnership, mas marami ako nakitang drawing na pampagising kesa sa corporation. Ang hirap kasi maghanap ng drawing sa corporation. Ikaw nga maghanap ka ng drawing ng doctrine of ng corporate opportunity. Ay, ewan ko kung anong picture mahanap mo. Now, in a contract of partnership, in the definition, there's an obligation of two or more persons to do what? Bind themselves to contribute money, property, industry to common fund, to divide it among themselves. So for the purpose of creation, kung a corporation, you can create a corporation with a corporation. So corporation plus corporation equals a corporation, pwede. Pero sa partnership, pwede bang natural person plus corporation? Pwede bang corporation plus corporation? No. Why? Because it is said that corporation cannot enter into partnerships, but joint venture. There is a discussion regarding joint venture, which we lifted from common law. But in civil law, joint venture is treated as a partnership as well. The only difference is that the Supreme Court had said that corporations cannot enter into partnerships, but only joint ventures. And joint ventures have the same definition of partnership. So the traditional thinking that joint ventures are just for a single transaction, hence temporary, is not applicable in our civil code, ha? Kasi in partnership, pwede namang limited, pwede namang partnership for a term or partnership for a particular undertaking lang. Ba? So, that application, that definition is not applicable here in the Philippine setting. We just lifted it from common law. Okay. Now, for separate juridical personality concept, there is the requirement of in writing if the amount would be above the threshold. So, if it is 3,000 or more, it must be in a public instrument recorded in the SEC. So, partnership can be in any form. It can be oral, it can be written. I copied from the website an example of a picture of the partnership. Kung hindi kayo nanonood ng Dragon Ball Z, hindi ko kasalanan yon. Bakit? Kasi nagsama si Goku at si Vegeta. Ano ginawa nila? Nag-fusion technique. At anong nangyari? You created Gogeta. He is not Goku or Vegeta, but a combination of both, which is a separate entity from Goku and Vegeta. O sige, manonood kayo mamaya ng Dragon Ball Z at hanapin yung episode na nag-fusion dance sila. Now, since it is a separate personality, paano kung law firm? Is a law firm a separate personality because that law firm is a partnership? Well, in the case of SAFA Law Office, sabi ni Attorney Saludo, the one who entered into contract is the law firm, not Attorney Saludo, who is the managing partner. So, when the law firm was not able to pay rentals, dinimanda ng PNB, yung lessor, ang nagkaroon ng demandahan where the party was sued is the PNB as well as Attorney Saludo, who is the managing partner at that law firm. Now, PNB would like to include SAFA because the law firm SAFA is the one who entered into contract with PNB. It's just so happened that Attorney Saludo is the partner, managing partner. So, must there be inclusion? I've said earlier that the law firm has an entity separate from that of the partners behind them. Separate juridical personality also applies in partnership. Therefore, the inclusion of SAFA law firm is a must. How about the argument of Attorney Saludo na may usapan kami na partners na ako lang ang sasalo ng utang? This understanding or agreement is only between them. It will not bind third persons, including creditors. That is why creditors can still go after the other partners, though the other partners would have a recourse to go after the erring partner. So, for this rule, of course, every rule has an exception. We have a new case, the case of the magaan spouses. The Magan spouses had been operating a partnership, pautangan lending. Now, this partnership stopped in 1999, but the spouses had been continually doing the lending business. And there was someone who squealed that they are just one and the same. Yung IMELEC Trade House, the partnership, and Magaon spouse are just the same. So the BAR is now assessing taxes. It was also proven, however, that IMELEC is a registered partnership with separate personality. Therefore, to pierce the personality of the partnership, there must be clear and convincing proof to that effect. So, what was applied here is also the same concept in corporation of piercing the veil of corporate fiction. So, here it was not proven, however, that partnership IMELEC is the same as that of the spouses. Ito ay nagkulang lang sa evidence, pero it's possible that the veil can be pierced to show that the partnership is the same as that of the spouses behind them. Paano tinatanong sa bar ang partnership? It's via application of whether or not there is a partnership. Just because you are receiving money, gross returns, is not enough proof of partnership. Co-ownership is also not proof of partnership. That is co-possession. If you receive money because it's from a partner, it's possible that it's not due to your share in the returns, but it could be payment for a debt, wages of an employee, annuity to window, interest on a loan, or sale of a goodwill. Okay? We have two cases illustrating differences between a co-ownership and partnership. Because for tax purposes, a partnership can be taxed. In co-ownership, there is no taxation. In the case of Obilios versus CIR, the siblings inherited property from their parent, and they could not build a house in that property. So what they decided is to resell the property and divide the proceeds among them. So is that a partnership? That is actually a co-ownership. A dissolution of the co-ownership. When the profits were divided, that is because of the dissolution of the co-ownership. So just because they received certain money or profit is not proof of a partnership because there's no intention to form. But what happened is, after extrajudicial settlement, the heirs used the inheritance and pulled it into common fund to produce profit. This time, the answer will be different. There is already an unregistered partnership for tax purposes. Why? Because their rights are already settled at a certain point in time. When there is extrajudicial settlement, the definite shares of each heir is already known. So when they decided to pull it, then there is an intention then to form a partnership among them, although this is an unregistered partnership. Let's take new cases, like in the case of Santiago versus Spouses Garcia. If you invested money with someone else and then you're expecting 5% return to 8% return, is that a partnership? Because it was argued that the one who received money is the industrial and the one who infused money is the capitalist. But no other evidence was shown aside from that allegation. There is no partnership because of proof of absence of how profits and losses is to be distributed, how would the income be computed. So mere receipt of money is not proof that this is a partnership. This is the usual defense when a person is sued for estafa. Because when they would cry that there's a partnership, it's no longer criminal, it had become civil liability. So the criminal case will be dismissed. This is also some of the cases I encounter. In the case of Dusol versus Lazo, where the spouses are caretakers of beach resort, and they're receiving salaries or commissions from the rentals of the cottages, when the beach resort folded up, does it mean that they are illegally dismissed and hence the beach resort is mandated to pay them separation pay? The answer is there's no partnership among them. Thus, they are entitled to pay separation pay because they are actually employees of the beach resort. So there's also no proof on how the profits are computed, how the losses are distributed among them. Can there also be a partnership by estopel? Kasi similar sa corporation na may corporation by estopel. Yes, when third persons believe in good faith that there is a partnership. How? By representation, by words spoken, written, by conduct. Third persons would be given credit under the belief that there is a partnership. Therefore, that purported partner will be liable for the liabilities incurred as a result. I said earlier that there is the requirement that a partnership be in a public document registered with the SEC when the capital is 3,000 or above, or when there are real rights. But what if, despite that requirement, they entered into an oral partnership? What is the effect? This requirement is only for third persons. So among the partners, then there was still a partnership. And if there are third persons who believe in good faith and there's a partnership, then what we apply is a partnership by estopel. In the case of verge trading, where there was infusion of investment, which is above the 3,000 threshold, the one of the partners said that she is not thou a partner. However, the name of the business was in her name. Acronym, VEG. One of her name is there in VEG. And then they had an agreement regarding the finances. And later on, when they were already quarreling, she went to the barangay and saying that I am already disassociating myself from the partnership. Well, that is actually also partnership by estopel. That oral partnership then is binding among all of them. Now, since the entity itself, the partnership, was unable to pay because it is in the first place not a partnership, who then will be held liable? Then it will be the partners in that purported partnership. So oral partnership, okay, that's done. Let's go now to a partnership among spouses. Kasi natanong na to sa bar. If there's a partnership among spouses, will it be valid? The prohibition is a general partnership. Why? Because there are persons prohibited from making donations to one another, including the spouses. These persons, under the civil code, cannot enter into universal partnership. Therefore, we have to make a distinction. What kind of partnership was entered into? Because if it is universal, hindi pwede. But for particular, pwede. In the case of CR versus Sotera, there is a limited partnership, and there's a general partner and a limited partner, and the general partner and the limited partner married. So, what then would happen? Is it prohibited? This is a particular partnership, not a universal one. Example, practice of profession. That is a particular partnership. So, husband and wife, pwede. At what point will a partnership start and end? It will start from the moment of the execution of contract and end depending upon what is the agreement. Because if it is for a fixed term or particular undertaking, then you have to wait for the expiration of the term or completion of the undertaking. But if there is no period, then it is at will, predicated upon the mutual desire and consent of the parties. So if the parties would have a squabble among themselves, can the partners then dissolve the partnership? Since it is a fixed term, it is now based on their mutual desire and consent. That is why any of the partners can dictate a dissolution. But this right is not absolute. Why? Because if the partner acted in bad faith, there will be liability for damages. If the partner acted in good faith, then there is no damages. Remember the delectus personae concept. So you cannot compel a person to be your partner. But even if there is a requirement regarding good faith, hindi naman ibig sabihin ay partnership cannot be dissolved because there is no good faith. No. What it means is that even if there's good faith or bad faith, a partner can unilaterally dissolve. However, if there's bad faith, there's damages. If good faith, there's no damages. And how can you see damages that entitling good faith or bad faith? That is factual. In the case of Ortega, which is the law firm of Attorney Misa resigned from the law firm. Therefore, the law firm is dissolved. Why? They are squabbling. So interpersonal conflict. So there's animosity. So this is not bad faith because this is what was not for the purpose of unduly visiting harm or damage upon the partnership. There is no conscious design to do a wrongful act for a dishonest purpose. This is due to their interpersonal conflict and that is not bad faith. So, ang tinatanong din sa partnership ay regarding rules in conduct of partnership. Can an industrial partner do business? Can a capitalist partner do business aside from the business of the partnership? Insofar as the industrial cannot. Kasi industrial siya. He is not allowed unless the partnership allows him. An industrial partner is supposed to give his effort, full effort. The only exception is if the partnership allows him. And if he violates, then the capitalist can exclude him from the firm or avail themselves of the benefits which were obtained in violation of the law. But if the partner is a capitalist, he is allowed to engage in any business which is not in competition with that partnership. So let's take the example of this car wash business where the capitalist had put up a coffee shop and the industrial partner put up a barber shop. Yung capitalist na coffee shop pwede because a coffee shop is not in competition with the car wash business. It is a different line of business. But if we take a look at the barber shop, hindi pwede because industrial partner must devote his full industry. But what if I change your problem? The capitalist will engage in a car waxing business. The car waxing business is related to the car wash business. Remember yung doctrine of corporate opportunity sinabi ko kanina. They must be in competition. Same line of business. And I submit that a car wash business is in the same line as car waxing. Okay? Kasi you have the same customer. The one who washed their car will have their cars waxed. So it can be a potential business expansion. Insofar as distribution of profits and losses, okay, ito yung example ko regarding a partnership who incurred losses and who also had income. So the Sailor Moon is a capitalist partner but managing at the same time, investing 500,000. Mercury, 500, Venus, 500, Mars, managing, Jupiter, industrial. But it was agreed upon that the industrial will not be liable for any loss. Kung hindi nyo kilala itong characters na to, bahala sa buhay nyo. Ngayon, it was agreed upon that the managing partner's liability is only up to his investment. Now, industrial partner's liability is only up to the not liable for any losses. These stipulations are only valid among them. Therefore, they are not, in so far as creditors are concerned, creditors can go after the separate property. But if they go after the separate property, these partners can go after the remaining or the other partners. So here we have income. How is the income divided? If there's no agreement, then pro rata. So, ito ang proof na kapag may law, kailangan pa rin ng math. Kasi paano mo i-compute yung distribution? Tinanong na to sa bar, how much should pertain to each partner? So, 1:1:1:2. Ganun ang pro rata. The same for losses, the same for income. But the question is, what is the effect of this limited partner who is managing partner as well? This is not a true limited partner because a limited partner is a silent partner. He must not manage. Therefore, the managing partner will incur the liability similar to a capitalist partner. Okay, this was asked already. Now, rules as to management. The one who should run the corporation is the managing partner. But if he was appointed in the articles, he may then execute all the acts unless he acted in bad faith. The power is irrevocable. But if the powers granted to be a managing partner is later on, after the constitution of the partnership, it can be revoked at any time. And who can revoke? Controlling interest, not the numerical number. So in the example I gave you here, the Bioman Enterprises, the pink 5 was chosen by blue 3 and yellow 4 was chosen by red 1. Since red 1, who is the capitalist, it so happens to be the managing partner, it is the choice of the managing partners which should prevail. The only exception would be if it will be revoked by the one who has controlling interest. And in the problem, the one who's controlling interest ay yung mayroong pinakamalaking investment. Alam ko na medyo natakpan yung figure, pero it's green 2 who has 1 million. Blue 3 is 200,000 only. So the one who's controlling interest decision must prevail in order to revoke. So, as to rules of management, madali lang to. I reiterated this. What is the doctrine of delectus personae? This is a Latin term meaning choice of person. You are not forced to associate with someone whom you do not like. But what if, example, ito, si Emerald Zagato, si Zagato, yung interest niya ay inassign niya kay Lantis through a deed of assignment. Does it mean that a new partnership is formed? No, because mere assignment is not a ground for dissolution. Now, can the assignee interfere in the management? The answer is no. The right of the assigned is merely to ask for the share of the profit, to get the share of the profits. But what if the assignee questions the computation of the profits? That's why he would like to examine the records. Can that be done? No. This right is not to the assignee. It belongs to a partner. It is personal in character and cannot then be assigned the right to examine the records. Only a partner can do that. So if there's a transfer, it does not create a new partnership, nor entitle the assignee to the rights of a transfer, of the transferor, the right of a partner. So, kapareho pa rin ito, yung example ko dito sa slide, na Sakamoto Enterprises. Just because there was a assignment, it will not result to a dissolution of the partnership. So, reiteration. What would be the liability of partners to third persons? The liability is general rule, pro rata. Exception, solidary when there's receipt of money from third persons. So, the partnership is bound to make good the laws. If a partner acting in a parent authority, receives money for a third person and misapplies it. So, hindi ba yun unfair? Well, whether you are innocent or guilty, all are equally liable because the law protects third person. Therefore, if there would be an innocent party, the recourse of the innocent party is to go against the guilty party, but not to escape liability. In the case of Muñazque, si Muñazque is a partner of Galan. Si Galan binulsa lahat ng payment. That's why Muñazque had to shell off his own money to finish the construction. And can Muñazque now later on go after their client because the client paid Galan? There is the presumption that Galan was acting in behalf of the partnership. Therefore, they are presumed to be partners. The act of a partner would be an act of the partnership. So whether they're innocent or guilty is immaterial because the liability is solidary in character. The last topic for partnership will be dissolution and winding up. Katulad ito ng korpo kanina, dissolution, winding up, termination. So these are stages. In dissolution, the partnership is only, the duration of the partners are only changed because they cannot do business anymore. Okay. So dissolution at that point in time where the partners will cease to carry business. And in winding up, you settle business affairs. Example, you pay prior obligations, you collect assets demandable, or you hire a demolition company for the demolition of a garage because it is a used car partnership. So you can enter into contract, but not for the conduct of business, but for purpose of dissolution and winding up. And termination is that point in time where all the affairs had been wound up, meaning everything had been paid off, starting with the creditors and last would be the partners. This is a case where a partner had issued a check to her fellow partner because they're undergoing liquidation. The share of the part is 900,000, payable installments by check. But the problem is one of the checks bounced. That is why this partner was sued by his fellow partner for BP22. But there is no creditor-debtor relationship here to be the base of BP22. This is pursuant to liquidation and winding up. The check was issued to prove in good faith the share of the partner. And as proof that there is winding up, there were still unsold goods, uncollected receivables, which are still being collected during that time. So the case for BP22 would fail because it's not payment from debtor to creditor, but a check issued in liquidation of the partnership. Now, what if there was a third person who delivered materials to the partnership, but the partnership was dissolved and that person was not paid? In this case, that you see in the slide, siguro naman kilala nyo ang Voltes 5 kasi bago-bago pa pinalabas na sa TV. Okay. So Steve, Little John, and Big Bert had a partnership. Now, it's for the construction of a bridge. The bridge was delivered, tapos na turnover. The supplier, Dr. Armstrong, was not paid yet. So he goes after Steve. But Steve said, we are not a partnership anymore. It was already solved with the delivery of the bridge turnover. So can Dr. Armstrong then go after Steve personally? The recourse should be against the partnership first before going after Steve. So Steve will be liable for the proportionate share in case there are no more partnership assets. Just because the partnership had already been dissolved does not mean that there's no liability anymore on the part of the partnership. There's still a winding up and liquidation stage. So recourse first should be against the partnership before the partner for his pro rata share. For dissolution of a partnership, ang natanong na dito is all about continuation of the business. Ito rin yung merong Supreme Court case tayo. Okay. I've said earlier that there must be good faith so that there will be no damages. If there's bad faith, there is damages. And in any rate, whether good faith or bad faith, remember delectus personae. You cannot compel a partner to be a partner if he does not consent. And mere acquisition or assignment will not result to dissolution. This is the case of U versus NRC, illustrating that the sale of the partner's interest to someone else. So when the partners had already sold off their interest and they had retired and withdrew from the partnership, and the 82% is transferred to another group, and the 18% is retained by the old, then there is a new partnership which is formed because there is retirement and withdrawal of the old, creating a new partnership. Now, if this partnership was dissolved, who can wind it up? It's the last surviving partner who have, as long as that partner is not the one who caused the wrongful dissolution of the partnership. In the case of Prime Link and the Lazatins, the Lazatins contributed the land. Prime Link's job is to contribute the money, labor, and personnel for the development of the lot. But for 4 years, tiwangwang yung lupa. They have not finished with the development. That is why the Lazatins had the contract rescinded, the joint venture agreement, and demanded the return of the property. Now, since it was the fault of Prime Link, Lazatin has the right to continue with the winding up of the assets of the partnership. And when the lands were transferred to the Lazatins, this is only part of the the winding up of the partnership affairs, the partition and distribution of the partnership. Yung kaninang sinabi ko regarding continuation of partnership, na merong bar question in the past, siya Supreme Court case. Ito yung kwento. What if the partnership had dissolved because the partner dies or the partner retires and the remaining partners will continue the partnership? What then will happen when there are creditors? Okay. So, the creditors can go after both the old and the new partnership. This is the case of Benjamin Yu. So, anong story? Benjamin Yu is an assistant manager of the old. The old partnership, some of them died, some of them sold the interest to Co and Sapanta. And this Co and Sapanta continued the partnership. They moved office and they terminated Benjamin Yu. So Benjamin Yu, is he entitled to separation pay? Yes, from the old and from the new. Because the continuation of the business without liquidation results the creditors of the old also becoming creditor of the new. So there will be priority on the part of the unpaid employee for payment as against the retired partner who's also claiming for payment because an employee is considered a creditor. In the priority of payment, you pay off creditor ahead of the partners. So there will be a pro rata liability between the old and between the new. So, ito yung isa ko pang example. Kung hindi nyo kilala ang Sesame Street, bahala rin kayo sa buhay nyo. O si Ernie at si Bert, sila at kasama si Cookie Monster sa partnership. Pero ang namatay si Cookie Monster. And Ernie and Bert continued their partnership. They opened a branch. So, the creditors now demanded for payment of their obligations. So, who is liable here? Since Cookie Monster had already died, may cut-off tayo. So, the liability for Cookie Monster would be up to the time where he was alive, he was a partner. So, so far as Ernie and Bert, then the liability will be continuous because of the continuation of the partnership. Huwag kayong mag-alala kasi hindi naman tatanong sa bar ng math, ng computation ng how much is owed by Cookie Monster or by Ernie and Bert. Alam nyo lang yung concept. Problema ng accountant kung paano nila kukumputin. Basta alam nyo lang yung logic behind. Okay? So, I'll stop with this recourse for partnership kasi ito lang naman ang coverage ng bar regarding the topic. Sa partnership kasi may discussion like limited partner, pero hindi na siya kasama sa bar. Pero kanina discuss ko rin partly insofar as liabilities of a limited partner who is not a true limited partner, but because of his actions, he had become a general partner by managing the business.
Why Central Books?
Because it's the home of the best legal minds. Central Books has always been a good friend.
Shows Central because it's the best bookstore here in the Philippines. No one else.
Of course, the Central Books na magandang policy.
With so many authors, with so many books that are being printed day in and day out. It has, I think, the state-of-the-art machines that can really, transform all of these books very fast.
So I want to be part of that home of the best legal minds.
Central has been very accommodating, very flexible in terms of discussing with the arrangements and all throughout the process. So
that is the reason why it is really privileged to become the author of this Central Books.
Central Books was able to
establish a name in getting authors who are basically experts on their fields.
Well, they share the same passion as me, and they believe likewise in providing accessible quality education to the examinees, students and examinees, and they have produced so many authors.
Central Books is always ahead, up to date, hands-on, and very accessible to the authors.
Hands-on kayo. And you reach out to the lawyers, to the authors, and yung encouragement, and yung support, nandun talaga yung support.
Central Books really gave us the platform and opportunity to help the law students to bring out the materials for them, and in-encourage nila yung authors nila to create books for the students. So that's why I think Central Books is a great avenue for law practitioners, for lawyers, for judges to share knowledge to law students, and even to members of the bar.
It's just CBSI #1.
Okay, now for insurance law. Anong tinatanong sa insurance law? Although we have a definition of terms under the code, ang tinatanong dyan ay application ng elements of an insurance, which are PIRAG. Kanya tayo ng acronym sa buhay, ako ay PIRAG for elements. P stands for premium, I is insurable interest, R is risk of loss, A is the assumption of risk of loss, and G is, it is a part of a general scheme for distributing losses among those senior situated. We call this concept as the principle of risk distribution. Okay. So, what if you are a, say, lawyer, you are providing retainer service to a client. The client might not have a case this month, pwedeng meron, pwedeng wala. Is it doing an insurance? If what was agreed upon is services similar to healthcare providers, it is not considered doing an insurance contract, although it has these elements. Why? Because the primary purpose is rendering service. In HMOs, they are indemnifying you up to a pre-agreed amount. But the principal object and purpose is still doing service. Indemnification is just one of the part. That is why it is not insurance. Okay? Now, how then will you know that whether the contract is an insurance contract or not? You apply all the elements. It is not by the term used. For example, the term used is protection indemnity club. In the case of Wild Gold Marine, it says what is the test. You look at the nature of the promise, the act to be done or performed, the nature of the agreement. It is not by the nomenclature. It is not by what it is called. Okay? So, tinatanong din sa bar via application ang elements at nature and characteristics. I have again an acronym IPEG-B. A means aleatory. Payment is subjected to the happening of future contingent event, but it is not gambling. Why? You take an insurance in order to avoid misfortune, but you gamble to court fortune. Sa Tagalog, pag ikaw ba ay sumugal, anong panalangin mo? Di ba sana manalo ako sa loto ngayong gabi? Pero pag ikaw ay kumuha ng insurance ngayon, ang patalangin mo ba ay, sana Lord, kunan muna ako ngayon? Di ba hindi? Magkaiba. So, it's all subjected to the possibility. However, the reason behind we take one is different. I is indemnity for property and investment for life. Why indemnity for property? Because you follow the concept of strict indemnity. You're not allowed to profit for your loss. If your house is 5 million, hanggang 5 million ang insurance. But life is investment contract because there is no peg valuation for human life. P is personal, so it's not capable of substitution because insurance company took into consideration your personal circumstances. E is executory and conditional on the part of the insured, but executed, so on the part of the insurance company, but executed the part of the insured in good faith or obirima fides for both parties. It is adhesion or the fine print rule because your only job as an insured will be to sign the contract if you like. If you do not like, then do not sign. That is why interpretations are liberally construed in favor of the insured and against the insurance company. It is synalagmatic, meaning reciprocal or bilateral, because both parties are obliged to do something. The insured must pay the premium. The insurance company must pay the proceeds to the designated beneficiary. And insurance contracts are voluntary in general. Why in general? Kasi may insurances na mandatory. Example, we are employees. There is a certain amount which is deducted from my payroll via SSS and GSIS insurance. SSS, GSIS has a portion for insurance, making it mandatory. Or if you have a car, you have your car registered with the LTO. Diba that is also mandatory? You pay TPL. If you do not pay TPL, hindi re-rehistro ang kotse mo. So it is mandatory. But most insurances are only voluntary. We have two cases regarding insurances on voluntary. Sorry, one case pala. The case of Udulio where it distinguished one who is agency hired and one who is direct hired. If you are hired by the agency, of course, insurance is mandatory, compulsory. But if you are direct hired or name hired, rehired, pursuant to the labor code definition, it is only optional, not mandatory. So sa topic na insurance, ang number one tinatanong ay all about insurable interest. Lahat, kumbaga, ang heart ng insurance is discussion ng insurable interest. And what is that? It is that kind of interest where with the continued existence of person or thing, you're deriving pecuniary benefit. When the person dies, the thing is lost or destroyed. You likewise sustain pecuniary loss. Then that is insurable interest. It doesn't mean that you have a title. In the case of platinum, it's not by title, but possession of substantial economic interest in the property. Not just any economic interest, but must be substantial. Okay, let's take illustrations. This is insurable interest in life. I have this chart. This column for life and column for property. Dito muna tayo sa life. Okay. You have insurable interest over your life, your spouse, and your children. Example, can you take an insurance over your life and designate anyone as beneficiary? Yes, as a rule, because that is liberality. Can you take an insurance on the life of your girlfriend and you are the beneficiary? No, because the law requires relationship. And it must be a spouse, not a jowa or a fubu. Okay? Children, the law does not make distinction between legitimate or illegitimate children. Dependents for education or support refers to those people who are mandated to support one another under the Family Code 195-196. Pero tandaan nyo, wala nang iron curtain rule ha. Yung legitimate tsaka illegitimate side ng putative parents. What if you are an employee? Natanong na sa bar regarding you hiring a janitor, hiring a maid. They're the ones whose job is to clean your house, but if they die, your house will be madumi. Can you get an insurance over their lives? So pecuniary interest arising from employment is not just ordinary employer-employee relationship. It must be of such a quality where with the death of the person, the employee, there will be material injury to the employer. So interest among partners, but up to the amount of the interest in the property. What else? Where itong person under legal obligation to pay money, meaning creditor-debtor relationship. I am highlighting a particular case, the case of De La Fuente versus Fortune Life. What is the story? Creditor, nagpautang kay debtor ng 3 million. Kumuha na life insurance sa debtor sa buhay niya, payable to creditor. Ang insurance policy ay 15 million. Nanganak ang utang, umabot ng 16 million. Namatay si insured and nagkaroon ng partial payment na 2 million. So how much is the insurable interest of the creditor? Is it 3 million, the beginning of the loan? Or 15 million, the value of the insurance? Or the value of the loan at the time of death? It is the outstanding obligation at the time of death. Why? Because when an insurance was taken by the debtor on his life, what he meant is that the insurance is be a collateral for the loan. So it will always be the outstanding obligation at time of death. In this case, there was partial payment of the loan, kaya yung 16, naging 14 million na lang. Now, is there any difference between insurance taken by the creditor on the life of the debtor versus one taken by the debtor on his life payable to the creditor? So when a debtor takes an insurance on his life, payable to the creditor and there's full payment, the proceeds will go to the estate. Full payment will not invalidate the policy. But if it is the creditor who took an insurance on the life of the debtor and the loan is fully paid, then there is no recovery on the policy. Not even the estate, because the debtor is not a party to the contract. Kaya walang recovery sa estate. Okay? So what else? Balikan natin yung kanina. It will be also any person in whose life any estate interest vested on him depends. In life insurance, the beneficiary can be anyone. Anyone because it is revocable based on liberality. You took an insurance on your life, designated as beneficiary your parents. Nag-asawa ka. Pinaltan mo yung parents mo, nilagay mo na asawa mo. Can your parents complain? No, because it is revocable based on liberality. E paano kung sinabi ng nanay mo na, o yung asawa mo ay may kabit. So sa galit mo, tinanggal mo yung asawa mo. Binalik mo yung magulang mo. Eh, gawa-gawa lang yung kwento. Can your spouse complain? And he be reinstated? The answer is no. Because it is based on liberality. Even if it is based on a wrong premise. Because based on liberality. The exception would be if the designation is revocable. Because once it is revocable, you have acquired vested rights. So the policy cannot be changed, the beneficiary cannot be changed, you cannot add, you cannot allow creditors to take the policy, you cannot allow creditors to get the cash surrender value. You have no more right over the policy, okay? Because it's already vested on the part of the beneficiary. Also, remember, if the insured dies without changing beneficiary, magiging vested na yung right ng beneficiary over the insurance because only the beneficiary, the insured who can change it. Hindi to transferred to the heirs, okay? But this rule again has exceptions because if it is irrevocable, but this is a void marriage, the guilty spouse can be removed as beneficiary. Or if you are the principal, accomplice, accessory in willfully bring about the death of the insured. Merong case, example, 2008 Barto. Kumuha ng insurance si tatay. Yung beneficiary niya si anak. Si anak, pinapatay si tatay. Kumanta ang hard killer. Question, can the insurance company deny liability? The answer is no. Because even if the beneficiary, the anak, is disqualified, the proceeds will still go to the estate of the tatay. So, meron pa rin maghahabol. Okay? Now, there are people who cannot donate to one another. That's why they cannot become insured. They cannot become beneficiaries in an insurance. Among the enumeration, you see in the slide is number 1, persons found guilty of adultery or concubinage. The case of Maramag versus Maramag. Okay, anong kwento? Si tatay, may legal family, may anak. Pero meron siyang kabit at may anak kay kabit. At kumuha ng insurance na ang beneficiary ay si kabit at anak kay kabit. So, na namatay siya, ang ginawa ng legal family ay, sabi ng legal spouse, oy kabit, ang share mo dapat akin. Tama ba yun? Sabi ng Supreme Court, hindi. Why? Because the beneficiaries include illegitimate children. And illegitimate children are qualified beneficiaries. Therefore, the share of the common law should go to the illegitimate. So, sabi naman ng legitimate children, oy mga kapatid sa labas, maghatian tayo. Merong succession legitimate 2:1. Tama ba yun? Hindi. You do not follow the rule on succession. Because what you follow is the rule on insurance, which allows recovery for illegitimates. So this decision is quite criticized, pero tayong magagawa. Yan pa rin ang ruling natin sa Maramag. Now, when are you supposed to have insurable interest over your life? Only at one point in time. At the time the insurance takes effect. No need to look thereafter at the time of loss. Halimbawa, mag-asawa kayo ngayon, pero hindi na kayo mag-asawa later on. At the time you took the insurance, mag-asawa kayo, there's no problem. The law does not take a look thereafter. Okay? And how much? It will be unlimited. I always have this chain question in this topic. Kayong magjowa, mahal nyo isa't isa. Kumuha kayo ng insurance sa buhay nyo. Ikaw lalaki, kumuha ng insurance sa buhay mo, beneficiary sa babae. Pwede ba yon? Yes, because there is no requirement that the two of you must have insurable interest in each other because you took an insurance on your own life. Pero kung kwento ay ikaw, lalaki, kumuha ng insurance sa buhay ni babae, ikaw ang beneficiary, ay iba ng sagot doon. Because this time, you must have insurable interest on someone else. And that someone else is not one of this enumeration. Hindi mo naman spouse and jowa lang yan eh, di ba? What if you took an insurance on the life of your jowa, you're the beneficiary, and then a policy was issued to you, and then years later, you get married? Is there compliance? Insurable interest is at the time the insurance was taken, you must be husband and wife. An example, magjowa lang kayo. Acquisition, marriage, will not have retroactive effect. You will not able to acquire an insurable interest because at that point in time, you're not married. Tandaan, walang retroactive effect. Okay. Paano kung mag-asawa kayo, kumuha kayo ng insurance sa buhay ng isa't isa, pero naghiwalay kayo ng landas, whether that is de facto separation or legal separation is immaterial. Because the law takes a look at the point in time when you took an insurance. Are you husband and wife? If the answer is yes, then there can be recovery. Paano kung nangyari ay lalaki, babae? Si lalaki, they're married to one another, husband and wife. Si lalaki ay nanlalaki din. At kumuha siya ng insurance sa buhay niya, ang beneficiary niya ay itong si lalaki din. Same-sex relationships. Pwede ba yun? Is this covered by the Maramag ruling prohibition? I submit no. Because the Maramag prohibition is all about a technical definition of adultery and concubinage, which entails opposite sex. So if it will be a same-sex relationship, there is no prohibition if you will apply strictly the provisions of the revised penal code. Kasi hindi yan adultery at hindi rin concubinage. There's no Supreme Court case yet, nor a bar exam question to that effect. Pero I always submit that you follow the technical definition. Now, let's go to property. Property would either be an existing interest, inchoate interest, and expectancy. Both are founded, anchored, coupled with an existing interest. Existing interest does not only mean ownership of a thing. Kasi kanina sa slide ko kanina, hindi lang ownership yon. In property insurance, it must be substantial economic interest. In the Platinum Group Metals case, his proof of ownership is photocopies only of the deeds of sale of the vehicle. So, the Supreme Court said that this is not, this is insufficient proof that he is really the absolute owner of the car. Pero, the car is in his possession, the trucks are in his possession. So there is substantial economic interest. These trucks are being used in that business and which was birthed by the purportedly MPA group. Okay. Now, what if you have not yet received the item? Bumili ka sa Shopee. Nag-click ka ng Shopee Insurance. Pwede ba yun? Hindi mo pa nare-receive ang item? Yes, this is what we call expectancy coupled with an existing interest. This is the case also of Filipino merchants. Why? Because you're expecting to receive that item. And the basis would be pursuant to a sales contract. Inchoate interest is not sufficient by itself. It must be founded on an existing interest. What if you are judgment debtor? Your house, you own your house, you took an insurance on your house, the house was sheriffed, foreclosed. The highest bidder won, and he was awarded a certificate of final sale. And he also took an insurance. So, dalawa ng insurance. What happens? Both of you are the original owner, and the buyer in the auction sale are both parties who can have an insurance. Because both have inchoate interest, founded existing interest. Why? In so far as the buyer is concerned, it's possible that he can redeem the property within 1 year. So his interest will become full. On the part naman of the highest bidder also can become the owner if the seller will not buy, the owner of the house will not buy back the property. So, pwede rin maging full or complete ng interest niya, hindi merely inchoate. Okay. In expectancy, ang laging example dito ay mga fruits of the trees, young of animals. Pero may isang bar na nagtanong about this scenario. there is a last will and testament where you are the tagapagmana ng mansyon. Excited ka, kumuha ka ng insurance. Nasunog yung bahay, namatay ang tatay mo sa sunog. Can you recover? The answer is no. Because what you had is a mere expectancy. It is anchored on the last will and testament, but that last will and testament will only operate on the death of the father. So it is not yet, the coupling requirement is not yet present. Okay? What if, say, your father took an insurance on the house, as well as a life insurance on his life, and your father died in the fire? Can there be recovery? The answer this time is yes. Why the difference? Because in the example, now, the one who took the insurance is the father who owns the property. In the first example I gave, the one who took the insurance is you, who is not yet the owner. Your basis is a will, which is not yet in effect, because the will only operate upon the death of that father. Okay? Now, in property, dalawa. Okay, ang requirement ay ang beneficiary ay merong dapat insurable interest in the subject matter. So you have a friend who took an insurance of his life and also an insurance in the house. Namatay siya sa sunog. Can there be recovery? Sa house, hindi, because the beneficiary is the friend. But in the life insurance, pwede si friend kasi hindi naman required na he must possess insurable interest in the life of the person. Now, in property insurance, you have to take a look at two periods. Take effect, time of loss. Did not exist in between. So, kung kumuha ka ng insurance, you are on January. You are the owner of the house. Pagdating ng February, binenta mo. October, nabili mo uli. November, nasunog si bahay. So, can you get the proceeds? Yes, because at the time the insurance takes effect, at the times of loss, January as well as October, you are the owner. Hindi required the entirety, January, October. Only on January and October, you are the owner. Okay? But if in November, you sold the house, and December, you filed a claim, pwede ba yun? Yes. Because you only lost interest in November, but the fire destroyed the house in October. So, it is always in October, which is the reckoning. How much? Unlimited. Ang life property is limited. Why? Principle of strict indemnity. You are not allowed to profit for your loss. Okay. So let's go now to examples regarding insurable interest. Okay. What if in the case of Asgard and Milestone, there are two parties. One owns the machine. One owns the equipment, and then the Asgard and Milestone had an agreement to create corrugated boxes. The machine, there are parts which were replaced by Milestone. So the machine is owned by Asgard, the parts are owned by Milestone. Nag-aaway silang dalawa. Tinanggal ni Milestone yung parts niya doon kay Asgard. So there was destruction of the machine. Can there be recovery from the insurance considering that the one who destroyed is not naman the owner of the machine? The Supreme Court said that interest here is not only limited to property ownership, even if the one who took the parts is not the owner, because of the agreement between the two per contract, that they have to create corrugated boxes, it is as if the owner of the part likewise has an interest over the machine per se. That is why claim here was denied, because it was self-inflicted. It was committed by the owner as if he is the owner per se. Okay. Ito yung kanina, Platinum Group Metals, about destruction of the trucks pursuant to an attack by the NPA. So even if the ownership was not proven because what they had then only photocopies of the deeds of sale or CR, there is still interest in the property. It's not purely ownership, because there is substantial economic interest. Why? These trucks are in the possession of that mining company and they use it in their day-to-day business. That is why that company would benefit with the existence and would suffer as a result of the loss. Okay. The cases of Cha is an example where the person has no insurable interest in the property. The second favorite topic here is about concealment and misrepresentation. Kasi kasama dito ang contestability clause. When you say concealment, where you did not communicate a matter which you must communicate, must this matters be within your knowledge at the time that you signed the contract? What if it is pending approval? Example, at the time you filled up the policy and there's a question about having prior surgeries. Sabi mo no kasi wala ka naman surgery. But after filling up the form and you submitted in the main office at the time that you had surgery, are you liable then of misrepresentation if you will not notify the insurance company? The answer is yes, you would be liable for misrepresentation. For concealment. Why? If the application is pending with the main office, there's still an opportunity for the insurance company to accept or reject the policy or impose a higher amount of premium. That is why it is material. Pero once the policy is issued to you, wala na magagawa insurance company. So if you acquired information after the issuance of the policy, then that is not concealment. The usual cases, bar exam cases as well in concealment are all about state of health of a person. Must there be a connection between the cause of death and the disease? Like, hindi mo sinabi na ikaw ay naoperahan sa puso. Pero namatay ka naman sa plane crash. Must there be a connection? The law does not require any connection between the two. The insured need not die of the disease he failed to disclose. This is the UCPB as an example of a case about concealment. But what was applied here would be estopel on the part of the insurance company, because the insurance company cannot claim that there was concealment because the original owner insured notified the insurance company of the change of ownership, and insurance company even amended the policy to reflect the name of the owner. So that is not really concealment. There is estopel, that is waiver on the part of the insurance company. Now, for what would happen then if you would misrepresent? There's the remedy of rescission. But this must be exercised before commencement of an action on a contract, meaning before a case is lodged in court. Ang dinidiscuss dito ay all about IC. What is IC? Incontestability clause. There are 5 requirements you see in the slide. Life insurance, payable on the death, 2 years record from issue date or last reinstatement, policy cannot be proven void or rescindable, and the grounds are only limited to concealment or misrepresentation. So, paano ito tinatanong sa bar? Simple, magbilang ka ng 2 taon. From issue date, lampas ng 2 years, then the policy cannot be contested anymore. Pag wala pang 2 years, you can contest the policy. However, there is an exception, the Sun Life versus Attorney Sibia ruling, because it appears that if the insured dies before the 2-year period, the incontestability period can be reduced to less than 2 years if the insured dies. So take note that in Sibia ruling, period can be reduced to less than 2 years if the insured died. So anong follow nating ruling? Yung original o yung Sibia? I always say the students answer the old ruling but add as additional sentence the Sibia ruling, because the Sibia is not an en banc decision. It's just a division ruling, and it say that we are already veering away from the ruling in ganito. Walang ganun kasalita eh. Kaya, we stick with the 2 answers. Total 1 sentence lang naman yan. Okay? So, cash and carry doctrine. What does it mean? Cash and carry means payment of premium is necessary to the validity of the policy. So, if you don't pay premium, there's no insurance. But what if you paid only partial? There's no requirement that you have paid the entire amount for the insurance to be effective. So partial payment makes the entire contract effective. If you pay through an agent, payment through an agent is payment to the principal. That is the case of Loyola Life versus ATR, where the payment were coursed through an agent and the amount paid is not the full amount but only a partial amount. But this cash and carry doctrine has exceptions. First is in case of life insurance because we follow a grace period. Example, kumuha ka na insurance ng January. Hindi ka nagbayad kahit piso. Now, may nangyari sa January 15. Pwede bang sabihin may grace period? Wala. Kasi 30 days grace period is given if there is initial payment. So, if we change the problem, January nagbayad, February hindi. May nangyari February 15, pwede na yun kasi may grace period na. Acknowledgement in policy of risk of premium is conclusive evidence of payment. If it is in installments, it's also required that there be a partial payment. Credit extension under broker and agency agreements. And estupel, where by the act, third person would believe that there was payment of premium because of the practice or actuation. And for employees of the government, including GOCC, can make premiums through salary deductions if the payroll is authorized to make deductions and to remit the same amount. What is double insurance? Double insurance has these 5 requirements. Same person, 2 or more insurance companies, same subject matter, interest, as well as peril. Okay, let's apply this scenario. Double versus over. Over is simply insuring above the insurable interest. So if the house is 5 million and you took a fire and flood insurance, you don't mix the two. That is why there is no double and there's no over. But if you take the same fire insurance with the same insurance company, though there is no double insurance because the companies are the same. To have double, dapat different companies. Over insurance is simple math. 2 plus 2 is 4, hindi lampas. Okay? Now, if it's a mortgagor and mortgagee, these 2 people have different insurable interests. So, wala rin double insurance. Paano yung life insurance? Pwede bang double and over? There is the general prohibition in double insurance in order to avoid over-insuring. And this danger is absent in life insurance. Bakit? Because there's no peg valuation for human life. Okay. Paano tinatanong ang double tsaka over? It's the application of the principle of contribution. What does it mean? In case of over and double, the insured can claim payment in any order he selects, up to the amount the insurance companies are liable solidarily under the respective contract. When you use the word several here, it means solidary obligation. So each insurance company is liable to contribute ratably to the loss proportionately. Let's take the Malay insurance case. Fire insurance taken with company A and company B. So, dalawang companies nag-fit yung requirement ng double insurance over the same fire house. So, 5 million, pero ang bahay ay 5 million. 5 plus 5 is 10. So, double na siya, right? What would happen applying the principle of contribution? Balikan ng rules. The insurance company, the insured can claim payment in any order he selects, up to the amount insurance companies are liable under contracts. So, you are the insured. Kanino ka maniningil? Your option. Either go to A or to B. If you choose B, what then will happen? B must pay up 5 million because that is the maximum under his contract. But B has a right to be indemnified by A proportionately. So, 50-50 dapat sa A and B. So, B can go after A for 2.5. Hindi pwedeng sabihin ni A na, ligtas na ako dahil nagbayad na si B. No. That is how principle of contribution works. Natanong na yung application na yan, ha? The Wyeth case, an example of no double insurance. Why? Because even if the goods are the same, the ones who took insurances are 2 different persons. Wyeth and reputable. And they have different insurable interests as well. Kaya there's no double insurance. Ano yung collateral source rule? Okay, binabantayan ko to almost 9 years na. Collateral source rule is a civil law concept. This was originally applied to torts cases where it says that the defendant is prevented from benefiting from the plaintiff's receipt of money from other sources. So if the injured receives compensation, the amount should not be deducted. That amount should be deducted from the amount due to the tortfeasor, the one who committed the wrong. Because the one who committed the wrong should not be benefited by the receipt of the money. In the case of the Mitsubishi Motors, the Mitsubishi has a CBA with these rank and file employees. To CBA, meron silang benefit, which is hospitalization pursuant to CBA. But there are employees who have their own health cards. So question, can they claim double or twice? One from the health card, one from the CBA. That is actually unjust enrichment. Because the no-fault indemnity is not applicable to no-fault insurance. This case is a case of no-fault insurance. Bakit? Tindan nyo, collateral source rule is about tort. Tort means there's someone who committed a wrong. This is a no-fault insurance. There is no one then who committed a wrong. That is why we cannot apply the concept of collateral source rule. So there can only be one choice insofar as recovery. Okay? Now, last topic in insurance is about reinsurance. In reinsurance, it is one where an insurance company gets a third person to insure himself against loss or liability because of an original insurance. I was able to get a good picture in the website. If you're an insurance policyholder, you took an insurance company to insure you. And that insurance company, yung red na payo, will get another insurance company to protect itself in case it will be paying you. We call that reinsurer. So a reinsurance contract is a contract against liability, not merely against damage, because the liability of the reinsurer will happen when the peril insured against on the part of the insurer will occur. There's no need for the insurer to pay up first the policyholder, because when liability arises, the reinsurer's liability is already there. There will be a right to recovery. So they call this insurance of an insurance. What is the difference between double and reinsurance? Because in reinsurance, the original insured is no longer a party, but he has no more interest then. But in double insurance, the insured in the first and second are just the same. So the interest of the original insured in reinsurance is not needed because he is not a party in a reinsurance contract. Okay? But in a double insurance, it is still the same insured who's there. Merong doctrine ng baganda sa reinsurance. Anong doctrine yun? Follow the fortunes or follow the settlements doctrine. It says that the reinsurance or the reinsurer is bound by the decision of the reinsured regarding payment of claims as long as it was made in good faith in order to prevent the reinsurer from second-guessing the settlement decisions. Therefore, if the reinsurer should automatically pay if the reinsured pays the original insured. In the case of FLT Prime, there is an insurance taken by Top Forest FLT Prime. Si FLT Prime, kumuha din ng insurance with solid guarantee for that liability as well. When fire destroyed the property of Top Forest, nagbayad sa FLT. Now so the solid guarantee, when I question ang amount, saying that it was inflated. So with that action, it is not following the doctrine of follow the fortunes. Why? Because it is questioning the computation of the amount. So, since the application of the follow the fortunes doctrine involves determination of good faith, hindi pwede ang adjudication via summary judgment. So, the summary judgment here is not proper because the reinsurer is disputing the data used in valuation of the claim. So, tandaan ang follow the fortunes at yung exception in application of the follow the fortunes doctrine. Okay, we're down to the last topic kasi we're discussing only the major laws, intellectual property. Kasi ito yung mga core subjects na tinatanong lagi sa bar exam. What are the three basic intellectual property rights? We have patents, trademark, and copyright. When we say patent, we refer to invention. And there's a technical definition of what a patent is. Trademarks are those which are attached to the goods or services. Copyright would refer to last, literary, artistic, scientific, and scholarly works. Patents and trademarks require registration with the IPO, but copyright does not. Why? Even if there is already a Bureau of Copyright in the IPO, you don't need to register it with them because copyright is granted from the moment of creation. You only need to submit a copy to the National Library and Supreme Court Library for legal works. But it's only for record keeping only, for completing records only, but not to give you copyright. Patent is 20 years from filing date, no renewal, so it is not forever. Trademark can be forever because it can be renewed 10 years from registration. Copyright are there two kinds. It's economic right and the moral right of integrity, which is just limited. Lifetime plus 50, no renewal, but the moral right of attribution is forever, in perpetuity after death. So, clue, if you see R with a circle, it means that is a registered mark. Pag copyright, C with a circle, that is a, it means that it is an announcement to the whole world that is registered copyright. Kasi pag nakasulat TM lang, hindi pa yung registered, meron ka palang claim, hindi ka pa na-issuehan. Okay? What is a patent? So, how is it being asked? Via application of the elements of patentability. New, inventive step, industrially applicable. It may relate to a product, a process, or improvement of a product or process. What if the invention, purported invention, was sold first, and then a patent application was applied? What is the effect? Well, it is no longer new because it's already available to the world. Once a person discloses the invention, like offering it for sale, then the world is free to copy and use it with impunity. Second would be inventive step or non-obviousness. Who will say that it is a person skilled in art? Is it an expert witness? The answer is no. Is a person of ordinary skill in the field of invention. So if that, say you're an engineer, and your fellow engineer would say, "Oh, ang galing mo, naisip mo yan," then it mastered that test. But if your fellow engineer would say, "Ay, talaga naman ganyan kalalabasan yan," then that is not, did not fulfill the requirement of inventive step. The third one would be industrially applicable, meaning it can be produced and used in any industry relating to a product or a process or the improvement of the same. So, if it is an existing process, but you made improvement of a process that is patentable, like in the case of aguas where tiles are already old, tile making is already old, but the process of tile making was improved that it cannot now allow drilling and it will not break decorative purposes, then that improvement is patentable. Tinatanong sa bar ay lagi, what is patentable or not? What is subject of trademark or not? What is copyrightable or not? Okay. Doon tayo muna sa patent. First is discovery. Assuming that nakatingin ka ngayon sa buwan at wala kang makita, maya-maya may nakita kitang bituin. Yung bituin na hindi pa nararehistro, pwede mo bang i-register as a patent yung bituing hindi gaanong maningning? Ang sagot ay hindi because discoveries are pre-existing. Anything which exists now, what was just discovered by man is not patentable. Okay? Scientific theory was asked many times in the bar. Kung buhay pa daw si Albert Einstein, pwede ba niyang ipatent ang theory of relativity? Summed up in E equals mc squared. The answer is not. But what you can patent is the application of the scientific theory. Halimbawa, applying the law of relativity, the law of gravity, the law of thermodynamics, lahat ng law na yan. May naimbento kang gadget na lumilipad, the voice activate, kung ano-ano man yan. Well, that gadget can be patentable, but not the theory itself. The theory is public domain. Okay? For drugs and medicines, if you merely discovered a new form or property of a known substance, it does not result in the enhancement of known efficacy, or you merely discovered a new use for a known substance, or you mere use of a known process unless the known process results in a new product that employs at least one new reactant, then that would not be patentable. Let's take an example. This is my traditional example for all of my students. Ikaw ay may sakit sa atay. So may inom ka ng glutathione. Na-discover mo na sa kain ng glutathione, ikaw ay nagiging mestiza. Pwede ka bang mag-apply ng patent for glutathione as a whitening agent? The answer is no, because this is an example of a mere discovery of a new use of a known substance. Pero kung paano gatong ginawa mo, ikaw ay umiinom ng Viagra. Naisip mo na yung Viagra ay pulbusin. Lagyan mo ng tubig, i-mix-mix mo, tapos i-ref mo overnight. Kinabukasan, yung buhok mong esponghado, nalagyan mo ng Viagra. Aba, ay tumuwid. This time, can you get a patent for Viagra as a hair straightener? The answer is yes. Why? Because it will fall under third one. It is not just a mere use of a known process, because this process resulted in a new product which employed one new reactant. Remember in the story, you added water, mix. So it's a different process. This time, it is patentable. Pero don't attempt dahil hindi ko alam kung tutuwid ang buhok nyo sa Viagra. Next, schemes, rules, and methods of performing mental acts, playing games, doing computer programs, because computer program is a software. A software is copyrightable. In the Philippines, doing business is not patentable. But in other countries, it is patentable. I have undergone training in IP in Japan. Doing business is patentable in that country. Treatment of the human-animal body, but this will not apply to products. Example, meron kang baras sa puso. So, tinanggal yung baras sa puso, dumaan yung stent sa singit papunta sa puso, sa vein. So, the process, the method of treatment is sasaksak sa singit para makaakyat. That method of treatment is not patentable because that is to save human life. But the stent itself, the inflating metal balloon, that is the one which is patentable because that is a product. Okay? Plant varieties, animal breeds, or essentially biological process for production of plants and animals, but it does not apply to microorg. Example, ikaw ay nag-swimming, umahon ka sa dagat, meron kang kasabay na umahon na hindi mo maintindihan kung hayop o halaman. So, pinangalanan mo na lang Petmalu. Pwede mo bang i-register si Petmalu? Hindi, because Petmalu is a plant variety or animal breed. This is a discovery. Like an example of nag-garden ka, nakahukay ka ng buto ng dinosaur, hindi yun patentable. Okay? Aesthetic creation. Why is aesthetic creation not patentable? Because aesthetic is beauty. If it is beauty, it is copyrightable. But we have the Nicola test. Tinanong ang 2000 bar and the Nicola test. Ano yun? If the aesthetic and functional considerations have merged, you cannot separate one from the other. You cannot get a separate copyright protection for it. Only patent. Okay. Example, aesthetic creation. Design of a bra. Bra is just aesthetic. However, if that bra has functional considerations like yung bra pala ay may fingerprint recognition facility na pag may humawak na ibang tao ay makukuryente, eh di hindi na yan aesthetic, may functional yun. Okay? And last one, which is anything contrary to public order or morality, because we follow the moral utility doctrine. There was one bar, the 1989 bar, where the question is about gambling. So, gambling is regulated. That is why it will be contrary to moral utility doctrine. Now, who owns patent? Inventor, heirs, or assigns. Therefore, if the inventor dies, it will be passed on to his heirs or assigns. If there are two or more persons who made the invention, we follow the rule in co-ownership. So it will be jointly owned by them. We follow the first to file rule. Hindi na tayo first to invent kasi noong unang panahon, old patent law is first to invent. The problem with the first to file is, what if the true inventor was not the one who filed it first? There is a remedy granted by law for the true inventor. He can ask for cancellation if he really is the true inventor. Kaya meron namang remedy ang real inventor. Commissioned work. The rule on commissioned work is the same with copyright. Ano yon? If that is your regular duty, even if that is not your regular duty, even if you use company time and resources, the invention is yours. But if that is part of your regular assigned duty, that invention belongs to the employer. Example, it was asked in the bar, ikaw ay engineer, nakagawa ka ng gas-saving device using company time and resources. You're an engineer, but that is not your job description. You are in another department, mahilig ka lang magkutingting. So, this invention of yours, even if you use company time resources, is owned by you. But if you were hired to invent, kahit iba ang na-invento mo, that invention of yours belongs to the employer. We do not follow shopwright rule, which is the right granted to the employer to exploit the invention of the employee who use company times and resources. We do not follow that shopwright rule. Pang US lang yan. So priority, if there are benefits afforded to Filipinos in that country, then the same benefit could be given to foreigners here in the Philippines. So, a patent holder does not have absolute right over an invention because this can be limited. If it was placed in the Philippine market with a product owner or private non-commercial or experimentation or individual case of medicine or invention used in any vehicle of other country entering Philippine territory, hindi yan natatanong sa bar. Ang natatanong sa bar dyan ay regarding taking by the government. Why? Police power of the state. In case of national security, nutrition, or health. Example, you were able to invent a drug which will cure all illness, a breed of palay na hindi kailangang laging basain, a voice-activated bulb na pag ang boses ay soprano ay sasabog. So this time, it will be taken by the government, even without agreement of the owner of the patent. Infringement of patent, dito na tayo sa wakas, mayroong Supreme Court cases. You infringe patent when you make, use, offer for sale, sell, or import a patented product or a product obtained directly or indirectly from patented process or use of patented process without authorization of the patentee. So, importation is also patent infringement because this was obtained directly or indirectly from a patented process or the process was without authorization. To determine patent infringement, there are tests, the literal infringement and the doctrine of equivalence. In literal infringement, the court will just juxtapose the claim of the patent and the accused, meaning pagpapatuhin, juxtapose. And when the court sees that there is exact identity, then that is already infringement. But that is easily caught. That's why people would make use of the doctrine of equivalence. The function way result, the triple identity test, meaning if it performs the same function and the same way and the same results achieved, then there is already infringement. Let's say, I recall an old case of the Smith-Klein-Beckman, which is about a drug. So, drug A and drug B are both for treating parasites in the intestines of animals. So, they have the same function, kill worms. Same result, uminom ng gamot, patay bulate. Pero walang infringement kasi sa W aspect. Way. It was not shown how the parasites, the worms died in drug A, drug versus drug B. Ano yun? Sumabog ba ang bulate? Natuna ang bulate? Na-freeze ang bulate? Wala namang nag-testify na bulate. Kaya wala nakaalam ano ang kinamatay ng bulate. Okay? Ito na. We have two new cases regarding this. The tuna processors case. Tandaan, bago ito, these are the landmark case explaining patent infringement. Okay. Direct and indirect patent infringement. Direct is expressly found under 76.1, where it says making, using, offering for sale, selling, importing. These are direct infringement. Indirect, however, is the act of one person in inducing another to infringe a patent. Or you contributed infringement of the patent. Therefore, in order for indirect, dapat there must be a direct infringer. There can be no indirect, there can be no contributory if there is no direct infringer. Let's take first, there are two tuna processors case. Let us take first the first tuna processors case. In the case of Philips Seafoods versus Tuna Processors, 2023 case. Ang kwento nito ay si Yamauka, meron siyang patent for curing tuna. Si Philips, meron din siyang sariling patent claim. But Yamauka's claim is that the tuna is exposed to 0 to 5 degrees to filtered smoke in a cooling unit between 0 to 5 degrees. And so, the tuna is injected with that smoke. Si Philips naman, walang ganong cooling unit. Kasi ang filtered smoke is only allowed to cool to an ambient temperature before injecting. So, is there an infringement? The function and the result are the same. Both are function to cure tuna meat, and the same result as achieved is tuna meat is cured. But the way is different. One uses cooling unit 0 to 5. One does not use cooling unit, ambient temperature. No evidence is presented to prove that simultaneous cooling will produce the same high preservative and sterilizing effects as that of pre-cooling. Okay? Pero hindi dyan nagtapos ang tuna processors case. Kasi sa tuna processors, nanganak pa about contributory infringement at indirect infringement. Bakit? Dito muna tayo sa explanation ng Supreme Court paano nagkakaroon ng infringement. Okay, let's say, patent A, the original patent, has 4 claims, A, B, C, and D. Now, another product would then use elements A, B, C, and D at nagdagdag ng E. This is direct infringement kasi juxtapose, pinagpatong, nagpare-pareho, kinuha mo A, B, C, D, E. Then this is automatically direct infringement. Now, what if, in another case, what you did is, hindi mo kinuha lahat. So, it is not, the second one did not infringe directly. It's indirect because may tinanggal kang isang aspect. But this is just indirect infringement. Okay? Because the elements are not the same. May tinanggal kang element dog. A, B, C, pag pinagpatong mo, si A and B and C nandun pa rin. So, there is indirect infringement as a result. Okay? So, here, in the case of tuna processors versus Frescomar, ito ang nangyari, yung drawing na ito. So, there is a patent, and then merong item A, B, C, D, and E, dadagdagan ng E, and now, a third person, company X, induced the producer of product B to use the elements of patent A. So, X is liable by inducement. The one who produces product B is the one liable for direct infringement. Okay? Kasi pinag-juxtapose, may direct infringement. Si Company X, sabi niya, gamitin mo. That is why he is liable for, because of the inducement. Okay? There will be liability from the part of X, Company X, for inducement. Ang contributory naman ay, so, the same picture. A, B, C, D. Then, A, B, C, D plus E. But what Company X did was, knowing that element A can only be used in infringing patent A, provided the producer of product B with element A. Sa kanya nang galing yung element A. Okay? So in this case, Company X will be liable for contributory infringement because he's the one who gave it to product B. Now, producer of product B is liable for direct infringement because the one who made it everything. Di ba? Pinag-juxtapose, A, B, C, D, dinagdag C lang. So, A, B, C, D, swak, direct infringement. But Company X, who just provided, is contributory. Okay, having that in mind, ganyan ang kwento. Yan ang nangyari sa tuna processors. Why? Balikan natin kwento. So, si Yamauka, yung may 0 type 5 degrees. So, si tuna processor was given the right to license and sub-license. the patent. This preceded from the 2023 facts. Kasi 2023 facts, hindi na-prove na si tuna processors ay infringer. Pero pagdating sa 2024 case, si tuna processor binigyan na ng license to the patent. So, ang ginawa naman ni tuna, pumasok with Frescomar. Si Frescomar processes seafood products and filtered smoke in canisters. Hindi ko ma-imagine ang smoke nandoon sa canisters. Nalala ko tuloy before na pumunta ako sa Lake Como, merong canned air. Ito naman, canned smoke. Ewan ko pa paano yun. So tuna learned that Frescomar is producing and selling filtered smoke in a can for Hawaiian International Seafoods. So si Hawaiian naman, nagbebenta ng seafood at canister. So dugtong-dugtong na ha. Now, did Frescomar infringe the Yamauka patent? So is Hawaiian then liable for contributory infringement? So let's take a look first at the Yamauka patent. Ano pa patent ni Yamauka? Method of curing tuna meat. Does it have patent over the smoke machine? No. Okay. So since it has no patent on the smoke machine, there can be no infringement then on that smoke machine. This is an independent claim which was not procured. Let's look. Ano ba yung claim? Burning smoking material, passing it through filter, cooling the smoke, and smoking the tuna. Walang nakalagay dyan about use of the smoke machine. That is why there is then no infringement. So not all the elements were performed, therefore there is no infringement. How about the filtered smoke? Can we consider this as an indirect product? Kasi 76.1 covers indirect or indirect product. A smoke is not an indirect product of tuna. Ano ba ang indirect product ng tuna? Anything also about the tuna meat is an indirect, but not smoke, because there is a definition of what directly or indirectly means. So, directly, in product obtained directly means without further transformation. But when you say a product is considered to be directly obtained, there is some when we talk of tuna, any byproduct of tuna would be a direct product of the tuna. But can you see anything about smoke coming from the tuna? Yun ang logic, kaya walang indirect patent infringement or direct patent infringement here, because the smoke has nothing to do with the tuna. Okay? Let's go now to for Hawaiian, kasi if there was no direct infringer, then there's also no indirect infringer, no also infringement on the part of Hawaiian by contribution. Let's go now to trademark. Lahat ng ito ay kilala niyong brand, trademarks. This is the proof why trademark must be registered. The mark is a difference between a mark versus collective mark versus trading. When you say services, the more appropriate term is service mark. But we collectively call them as trademark, because a trademark is for the goods. A service mark is for the services. For example, Jollibee sells, what does it sell? The food items, burger, chicken. So that Jollibee you see is a trademark. Now, on the right is Hotel Sogo. Ano yan? Hotel Sogo, yan ay trademark ng isang hotel, motel, mot-mot, so clean, so good. It sells services. Pero ang Jollibee at Hotel Sogo ay parehong kainan. Huwag kayong tumawa, impacto kayo. Collective mark means any visible sign designated as such in the application for registration, which distinguishes the origin. So, geographical indication, they have common characteristics. For example, sa Pilipinas, itong landmark landmark collective mark example, the Guimaras mango. If you see that G with the hand, with the fingerprint sign, it means all mangoes which bear that mark came from Guimaras and therefore has a characteristic, ano yun? Super sweet, which is true. I went to Guimaras and bought mangoes. Talaga totoo, super sweet. Now, even if the manufacturers or even if the growers are different entities, but they all came from the Guimaras region. Okay? Trade name, on the other hand, is different because trade name means doing business as. So trade names are not required to be registered because it's possible the trade name is different from the trademark, although there are entities who share the same trademark and the same trade name. Like SM uses that S&M, that's Shoemart, that is their trade name and trademark at the same time. But there are businesses where their trademark is very different from trade name. Like Rustans has R, di ba? That R in Rustans is a trademark. But the trade name is not Rustans, it's Store Specialist Inc. So it is their business name. Okay ba? Why do we have to protect trademarks? What are their functions? They indicate the origin or ownership. They guarantee that the articles come up to certain standard in the form of advertisement. So when you see this bag, you see that letter C, the Chanel trademark. So it has a standard. You see the, uy, mahal, uy, social, uy, imported, uy, yamanin. So all of this are met. Origin, galing France o Italy ba, o France. They come with a certain quality, matibay, mahal, yamanin. And it is an advertisement to the bag to which it is attached. You acquire trademark via registration as a rule, but there is a further requirement. You must file a DAU. What is DAU? A declaration of actual use, because you are required to use the mark. If you fail to use within 3 years, then it will be a ground for removal from the registry, because there's a requirement that you use it. Why? Because trademark, as opposed to patent, are renewable. Patents are not. Trademark is renewable because it is being used. So there must be proof that you're really using it. So you cannot register a mark. Ito to sa non-registrable, dito tayo mag-focus. Marami tayong cases on trademark infringement. That's why I'm focusing here. You cannot get a mark which is identical with respect to a same products or closely related goods or services, or resembles a mark that will likely cause confusion. So identical, whether or not the goods are the same or different. Second, in looking whether it's confusion, we have to apply to test the dominance and the holistic test. But hindi na tayo dominance, hindi na tayo holistic. We are already in dominancy test. Dominancy, look at the prevalent feature of the mark. It is the one just spelled out in the law. When you say dominant, you look at the prevalent. You look at the dominant feature, not the entirety of the marks, not of the package, not the labels, the packaging. Because if you look at those, that is the entirety. You look at what strikes you out, the prevalent, the dominant feature. This is the case of Taiwan Colin. In the Taiwan Colin case, what was applied here is the holistic test. There are both spelled the same. One is engaged in selling. This one is attached to televisions. The other one is attached to transformers, AVRs. And the Supreme Court said that those marks can coexist following holistic test. Because if you're a buyer, you're not deceived of their source. They are bought from different channels of trade. But when the Colin 2021 case came in, it's still the same Colin, but hindi na siya capital letter, small letter lang. Tapos yung I ay italics, malandi. The Supreme Court abandoned the old Taiwan ruling because that old Taiwan ruling is holistic, and now it is dominancy. The dominant feature is the word Colin, however it is spelled. Why? Because when you pronounce Colin, no one knows, are you referring to the capital Colin or the small letter Colin? Are you referring to the one with the italics or no italics? These are just the same. When you say Colin, it's items sonants, no difference. But it was argued that these are two different categories. One is home appliances, one is AVRs, transformers, and these are different categories. Well, there are, in the first place, all electronic products. They just differed in the subcategory. But even if they are both electronic products, and one is household items, one is repairs, etc., service classification is no longer a factor to determine whether related or non-related. Why? The NIST classification changes from year to year. So if you will rely on this classification, there would be no constancy in the answer. So the Supreme Court abandoned the product or service classification as an effect. Yeah. You will, the marks which are not registrable are also those which are identical, confusingly similar, etc. Well-known similar goods. So nakikita nyo, whether it is similar or dissimilar, 5 and 6, basta well-known, then that is not registered. Why? Okay. So we'll say that a mark is well-known. The competent authority refers to the Director General, Bureau of Legal Affairs, Bureau of Trademark, or the court. And there are criteria to know whether a mark is well-known. It is the knowledge of the relevant sector of the public rather than the public at large, including knowledge in the Philippines which is maintained as a result of promotion of the work. So, ano tong dahilan? What even if they are different, basta well-known internationally, even if the products are different, you cannot have it registered. Okay, that is the concept of trademark dilution. It is the lessening of the capacity of a mark to identify and distinguish goods services, whether or not there's competition or confusion. Example would be, the usual example given in class is the Levi's jeans. The Levi's jeans has nothing to do with, say, Levi's tricycle, motorcycle brand. E paano kung masirain ang motorcycle? So people will say, ay, mahina tatak ang Levi's, not knowing that Levi's motorcycle is not related at all to the Levi's jeans. So because you are diluting the capacity of the mark to be known. There is the case of Suyen, okay, which explained the dilution by blurring. In dilution by blurring, you impair the distinctiveness of the mark. In dilution by tarnishment, you harm the reputation. So example po kanina Levi's jeans and Levi's motorcycle, that is dilution by tarnishment. And dilution by blurring, you blur, you impair the distinctiveness. There is a gel of Bench. Suyen is Bench. The brand is Agent Bond. And the one who complained is the James Bond franchise. Bond Girl 007 and James Bond. Why? Because of the word Agent Bond. And agent in the James Bond film is James Bond, in all of the James Bond film is a secret agent. So they are riding, Bench is riding the popularity of the James Bond character. So people now would be confused because there are some sort of similarity. Why? What is if you look at the James Bond characters, all of them, kahit si Mr. Bean sa kanan, all of them have the same persona. What's that? A styled straight hair, well-kept man. So it is part of the package. So this Agent Bond would bind straight hair. So they have an allusion. Bench is alluding to the character, therefore, of James Bond. So hindi na pwede yung Agent Bond na brand tuloy ng shell. Lacoste versus Crocodile is a famous, Lacoste is a famous shirt brand. Crocodile, I do not know this. I only came to know that this Crocodile exists when this Lacoste came, because I have not seen a single boutique with a crocodile logo. It's always Lacoste. So what happened is that Lacoste filed for registration under old law. And, Crocodile applied for registration under old law. Now, what is the difference between the Crocodile logo and the Lacoste logo? Because Crocodile has words and the figure, the crocodile figure. And the Lacoste has no words. The Lacoste crocodile is looking on the right, the crocodile is looking on the left, and the drawing of Lacoste has triangles in the body, and crocodile has solid lines. So there are differences in how they appear. The form, arrangement, appearance, all different. Also, there was no trademark dilution because crocodile had been coexisting in other jurisdictions, Japan and Myanmar. So both Lacoste and crocodiles are coexisting in those countries. Therefore, there is no dilution then on the mark because people know that these two are two different items. Now, to prove that there is dilution, what Lacoste employed is a project copycat test. Okay, so there was survey evidence. Is survey evidence admissible? The answer is yes, if you comply with necessity and trustworthiness. Here, was there necessity? Yes, because the court finds, similar to the Ginebra San Miguel case, that consumer survey evidence is necessary to know confusion. But the problem is trustworthiness. Why? In the Lacoste case, the universe was not properly defined. They only chose randomly 450 respondents from GMA, did not tell what is the population size. Is this numerically representative of the consuming public? Remember that Lacoste is not an ordinary shirt. It is expensive, costing thousands. So the representative should be the correct population, the correct market. It's not just any one from class C, D. You should have a proper source, which is of course the market A and B. That is why the universe being not properly defined led to the loss of Lacoste in this case. So not the proper universe was sampled. Confusion could either be confusion refer to goods or confusion to business. And when confusion of goods apply, product confusion, a buyer would be buying one product having in mind that he's buying another because they look the same. In confusion of business, people will think there is some association between the two, when there is no association at all between two businesses like the Levi's motorcycle, the Levi's jeans, is a confusion of business. In confusion of goods, the goods would appear the same. So would be induced to buy one product in the belief that he is buying another because they look alike. Okay. In this case of Mang Inasal, was there confusion? The dominancy test being applied here. The dominant feature is the word Inasal. The one on the left is the restaurant. The one on the right is the chicheria. So both are different products. But since the law does not distinguish between the same products or different products, there is here infringement because of the use of the dominant feature in Inasal. Mang Inasal should not be deprived of its right should it later on decide that it ventures into chicheria. This case of Papa Boy, this was my report when I went to Japan for the IPO training. The dominant feature here is the Papa word because these are both condiments, ketchup and lechon sauce, found in the same aisle of the grocery. But you see, in this case appears to be overturned already, impliedly by Citibank. Because 3 years later, when Citigroup came in, the dominant feature there is not the word city anymore. Mas malala pa dapat to eh. Both our banks have ATMs, but the dominant feature here is the lion. Ito pa parehong sausawan. It's still the dominant feature daw is Papa, not the pig. So, in the city state, Supreme Court said the dominant feature is the lion. And they use the ulo of the lion because the owners here are Singaporean nationals. So, they're referring to Merlion. So, tandaan, pag naglaban ang baboy at leon, sinong mananalo? So, ewan ko lang, makalimutan nyo. So, dahil isa pang baboy, itong aming lunch kanina, the case of LRs at saka LRs with a Z. Before this case came about, akala ko, pareho lang itong dalawang ito. This is proof that there's a need really to declare which is which. Why? People thought that LRs with a Z is a branch or franchise of the one with the S. But the registered owner of the trademark is the one with the S, the LR Foods Inc. Okay? So the use of the bamboo tray device, pig device, etc. was prohibited on the part of LRs with a Z. Okay? And even if they are spelled differently, one is S, one is Z, it is idem sonans because they sound alike. One who says Caloocan does not know where are you referring to Caloocan with a K and Caloocan with a C. Pero backgrounder, sa totoo lang, itong MC at LR Foods ay magkamag-anak. Magpipinsan to, nag-away-away kasi lolo't lola nila, yung mga luntok yung may-ari. Tapos may mga anak, nagkanya-kanyang investment, at ang mga apo na ngayon ang nag-aaway. Okay? So, away ng mga pinsan. Now, you cannot register marks which are generic. I have a very good case on this. The case of Ginebra San Miguel versus Director of Trademarks. Director of the Bureau of Trademarks about the Gin Capitan. Gin Capitan is using the word gin. And Ginebra San Miguel is also using the word gin. Both means referring to gin or Ginebra. So when you say Ginebra, is it what kind of mark would that be? There are 5 categories of mark. The lowest is generic. The highest is the coined or fanciful. When we say coined or fanciful, it is of the highest or the strongest chance of registration because they have no real meaning, like Google, Kodak. Now, if you say Google, it means search. But that before, when you say Google, you don't know what this means. It has no such word in the dictionary. Similar with Kodak. Now, if you say Kodak, it means picturean mo ako, di ba? Arbitrary means words which have a meaning but no logical relation. Like, when you say Apple, the product naman is hindi Apple, kundi computer, laptop, cellphone. Okay? They have no connection at all. Next would be suggestive. They have some hint on the nature, quality, or attribute of the product without describing these attributes. So, if not bordering on descriptive, this may be allowed. Example, there's the case of Nestle about the master coffee. The word master is suggestive because it has a description with reference to the coffee where they put in their commercials Jaworski as well as Rico J. Puno, who are masters of their craft. So it means that the coffee is somewhat superior. Okay? But that is not really a description. Why? It's different from saying Lucky Me Pansit Canton. Pansit Canton is a description of the pansit. That's why it is not registrable, that part. But the Lucky Me, ayun ang registrable, hindi yung Pansit Canton because that is a description of the pansit. Descriptive, kasi sabi ko nga lang Pansit Canton, so this is generally not allowed. And the last one would be generic. These are words that name the species or object, hence not registrable. So when you say Ginebra, is it generic? If you look at the root word of Ginebra, it comes from a kind of juniper berry flavored grain in the Netherlands. So does it really mean that kind of grain? The factor is public perception. And based on public perception, the word is generic if the consuming public understands that the word refers to a class of product it purports to represent. Thus, if the public understands that the word refers to a third enterprise or business, it is not generic but descriptive. In this case, based on market research, Ginebra was able to prove that when you say Ginebra, 80% of the population knew that it means San Miguel. They do not know the juniper berry flavored grain. Okay? Kahit yun ang root word ng Ginebra. Parang we already abandoned the case in San Miguel versus Beer na Beer, where if you say Pale Pilsen to be a kind of light Bohemian beer in the city of Pilsen, Czechoslovakia, sige, spell nyo ngayon ang Czechoslovakia, hindi na yun ang ruling ngayon. Kasi parang we veered away with this doctrine in Ginebra San Miguel without directly saying that we already veered away from that case. So, those requirements for survey evidence were met in Ginebra because the population was correctly framed. Who is the population? Manginginom of more than 6 million. Class D&E. Mga high elementary or high school education, some college, fishermen, farmers, workers. These are the market of Ginebra. So it was an accurate market sample. So Ginebra is a descriptive mark, but it's already subject to trademark protection pursuant to the doctrine of secondary meaning. Bakit? Ano ba ang doctrine of secondary meaning? With a long time unfettered use of that word, it will be associated the minds of the public as referring to a particular good or service to an enterprise. Like when you say Ginebra, according to market research, it only means Ginebra San Miguel, the enterprise. That is why it is already registrable. So shape mark, the law already allows registration of shape mark because these are necessitated by technical factors. If it is just technical factor, hindi siya registrable. Or by the nature of the goods, the shape is not registrable. Like elongated necks for vinegars, for liquid, or uniform tin cans for sardines, for corned beef, kasi wala namang ibang pwedeng paglagyan ang corned beef except uniform tin cans. Sige, pagbalik rin nyo. Kung ang corned beef ilagay nyo sa bote ng suka at ang bote ng suka ilagay nyo sa lata ng corned beef, ewan ko kung paano nyo gagamitin. Yun yung ibig sabihin ng consists of shapes that may be necessitated by technical factors. So if there's a technical factor for that shape, that is why it is not registrable. So color, unless defined by form. So the 7-Eleven, the form of a 7-Eleven, you see, it's not just colors. There is a form required for under the law. But under the new rules 2023, color marks, motion marks, 3D marks, etc. are already registrable. But these marks must portray and acquire distinctiveness. So example, these marks, color marks, are itong shoes sa ilalim, masakit sa paa yan, kahit masyadong mahal. These are registered color marks with these companies. And lastly, contrary to public order or morality. Sound mark is not registrable yet in the Philippines, okay? It's only in other jurisdiction. That's why kayo manood ng pelikula, pag napakinggan nyo yung tunog ng Netflix na ting, yan, that is registrable in other countries but not in the Philippines. Pero yung salon pass, yung amoy salon pass, amoy matanda, that is a smell mark which is not registrable in the Philippines but in other countries. So hintayin natin baka magbago. As of now, for bar purposes, walang smell mark, walang sound mark pag tinanong. Now, these are grounds for cancellation. If the mark had become generic, okay, we've defined earlier what is generic mark, what is descriptive mark. Although, tayo ang gamit natin kapag isharon mo, meaning i-plastic mo na, isharon, before we came with the word isharon mo, our word was i-tupperware mo na, pero hindi naman tupperware yung ginamit. Cover ng ice cream, diba? Or i-Xerox mo. When I was in Japan, I had a training, my professor told me, Rocille son, in your country, Xerox will no longer be registrable because you use Xerox for photocopy. Hindi ko naman masagot si sir. Sabi ko, sir, pwede ko bang sabihin na Fujitsu, 2 copies, back to back? O, di ba? Hindi. O, hindi na ako nakipag-away doon sa teacher ko. Basta nakangiti na lang ako. Now, abandonment, registration obtained fraudulently, or fail to use a mark in 3 consecutive years longer. That is why you are required to file a DAU, Declaration of Actual Use. And lack of funds is not even an excuse. Okay, let's take cases illustrating fraudulent registration. This case of Kiso, Nipper. The one who was able to obtain registration is a distributor here in the Philippines. And the owner of the mark, the one who's using here, is Solingen, the one who is, ang bansa ba ito? Switzerland, I forgot the country, or Germany. So, the one who was able to register here in the Philippines is not the real owner. And that is what we call trademark squatting. When someone registers another's trademark as their own in a jurisdiction where the trademark holder is yet to register, that is trademark squatting. You are blocking registration of the original brand owner. So it may result in bad faith because you will be extracting benefit from the registered owner, okay, from the real owner, because you were able to register ahead. There's another case also fraudulent registration. The case of Gloria Maris. If you see this restaurant in meron may CCP na likod. Well, the one who was able to get registration is not the owner himself, but a person who was entrusted by the owner to go to the SEC for registration. And that person registered it in his own name. Okay? So, fraudulent registration. In the case naman of Mr. Gulaman, the one who was able to register is the competitor And the real owner was able to produce evidence that they hired someone, they commissioned someone to do the logo. Kaya, yan ang proof. Now, what if you use it in the website, in the internet? For the use in website, it must result to a within state sale or is targeting customers which reside in that country. So in the case of W Land Holdings, they were able to prove na Starwood Hotels pala has no hotel, but Starwood Hotels has a website in English. You can pay in peso. And there is a toll-free Philippine phone number showing that sales really coming from the Philippines. Of all topics sa trademark, ang paborito sa bar ay infringement versus unfair competition. In infringement, the cause of action is the unauthorized use of the mark. In unfair competition is passing off. You are palming off. You make it appear that your product is that of your competitor. Intent is not necessary infringement, but necessary in unfair competition. In trademark, registration is prerequisite, but not in unfair competition. Passing or palming off is making it appear that your product is that of your competitor. So in the case of the Fiesta Ham and the CDO Pista Ham, the boxes of the two are the same because CDO copied the box of Fiesta, making it appear that that is a product of Pure Foods. The Pure Foods is expensive, the CDO is the cheaper brand. So, in the case naman of Chin Chun Su, kung gumamit kayo nito at pumuti kayo, very good, kasi ako ay nagka-allergy. The manufacturer is found in the packaging, but the similarities outweigh the differences. Why? No one will look at the name of the manufacturer. They are both oval, pink shape with the Chinese characters. Therefore, that is unfair competition because no one will look on the name of the manufacturer. In the Petron versus Yao case, the Masagana gas is refilling Petron and Shell with Masagana gas, their own brand of LPG. And it's selling the Masagana gas not only in Cavite, but also in Makati, Manila, etc. Does it mean that there should be multiple cases of unfair competition? The answer is no. It is a continuing violation of the law. Unfair competition was committed here in Cavite. Kasi itong planta ng Yao ay nandito sa Cavite. I incidentally had a similar case of the Masagana gas. It's now pending with the Supreme Court. Siyempre, convicted kong Yao. Ngayon, sabi ng Supreme Court, dismiss yung ibang kaso sa Manila, Makati, because there's only one unfair competition case. However, does it mean that since the public is deceived, therefore, it's the public who should lodge the case? No. Because unfair competition is for deceptive trade practices, meaning this is for the benefit of the owners of the mark. If there is incidental protection to the public, that's it. But this is primarily for the protection of the owners of the trademark. Now, what if you've been using a certain trademark, but you've been using it in good faith prior to registration of the current owner? This is the case of Zynaps. In Zynaps, Zuneca versus Natra Farm, the one who was able to register was Natra Farm. But Zuneca was using the mark 2 years ahead. And Natra Farm was able to register the mark in good faith. This was asked already in the bar 2 years ago. So, these two medicines are different, treating different ailments. And the Supreme Court, since the Zuneca had been a prior user in good faith, what is the solution? Zuneca was asked to indicate in its packaging that these two products are different. So they were allowed to use also the mark because they are a prior user in good faith. Okay, so last topic would be copyright. What would be the extent of copyright protection? A copyright does not cover process. That is why what happens if there's only one way or very few way to express idea and the idea and the expression merged with the idea? then you cannot get a copyright for it anymore. Okay? Ideas are not protected because pursuant to the doctrine of fixation, it must be fixed in a particular form. Material form can be touched, can be seen, can be heard. Okay? Idea expression dichotomy says copyright extends only to the expression, not to the idea itself. Works copyrightable are two categories: the original works and the derivative work. A derivative work is a work based on a pre-existing work. So when say original work, ano yan? Book, pamphlet, articles, writings, periodicals, letters are all written. Number 3, lectures is oral. Okay, let's take an example. You wrote a poem at the back of your reviewer. Yung poem mo, hindi mo naman nakapublish kasi nakalagay lang sa reviewer mo. Then, you passed on your reviewer to a friend na magbabar naman kasi abogado ka na, mo pa. Your friend saw your poem and your poem was published by your friend. Siya ang kumita. Question, who has copyright? You have the copyright because you are the owner. Why? The law does not look on publication because copyright is granted from the moment of creation. Okay, so it does not require that it be published. That is why it's sometimes hard to prove copyright ownership because it reckons creation. And what is your proof of creation is a matter of evidence already. Newspapers, periodicals enjoy protection separate from the articles themselves. So if you submitted an article, your article is covered by copyright. The newspaper per se is covered by copyright, but the news is not because news is history happening today. That is public domain. So everyone can write about the Sara Duterte impeachment topic. But if that topic is in a newspaper and how it was written was copied, that is infringement. So lecture, sermon, oral works, my lecture now is an example. So if it is reduced in writing or not, it is reproduced without my consent, that is a violation. So letters, dramatico-musical composition, choreographic works, or entertainment and dumb show. So palabas sa TV, palabas sa pelikula, when we say dumb show, it means silent movies. Like Mr. Bean. Sige, magbigay kayo ng dialogue ni Mr. Bean. Isulat nyo ngayon. Now, choreography does not refer to a dance move or pose. It means related series of dance movements. Okay? Music is composed of two parts, the melody and the lyrics. Both would enjoy separate protection. Works of drawing. Okay. Ikaw ay nagpunta sa Louvre sa Paris at nakisiksik ka para makita si Mona Lisa. Sa totoo lang, hindi sulit kasi 30 minutes kang pipila, tapos wala pang 1 minute, sisipain ka ng nasa likod mo para move ahead. Tapos ang pangat-pangat naman ni Mona Lisa. Ang liit lang ng painting. So, yun ang kinopya mo. At pagdating sa Pilipinas, binenta mo as coffee table book cover. Did you violate the copyright over Mona Lisa? The answer is no. Why? Because even if that is a work of drawing, you correlate your answer in copyrightable works with public domain. Because who drew Mona Lisa? Clue, isa siyang ninja turtle. Sino doon? Michelangelo, Raffaello, Donatello, and Leonardo. Si yun, Leonardo da Vinci, hindi si DiCaprio. Therefore, there is no more copyright because Leonardo had long time died hundreds of years. Okay, so take note of your answer. Now, ornamental designs or models for articles of manufacture, including works of applied art. Applied art is artistic with utilitarian functions and a useful article. So there is functional and there is artistic considerations at the same time. Example, in the case of Olano, it's a hatch door. It has a design and it's a door at the same time. Pero spring and car bearing of cars are not works of applied art because there's nothing artistic in a spring or nothing artistic in a bearing. Ano bang bearing? Di ba bilog lang na bakal yun, kulay itim? O nasa ng art doon? Ewan ko din. Okay. So then they call a test. I already mentioned it earlier. Illustration maps, plan sketches. So anatomical diagram ni doktor or astronomical chart or yung plano ng bahay ni engineer or ni architect, it was fall under this. Photographs. Okay. Photographs were asked many times. There is a celebrity whose picture was taken by paparazzi and published in a newspaper. The celebrity cried copyright infringement. Correct? No. Copyright is owned by the photographer. Paano kung kumain kayo sa restaurant, tapos sabi nyo kay Kuya Waiter, pa-picture. And the Kuya Waiter took your phone and took your picture. Who owns copyright? It's owned by Kuya Waiter, not by you, because he is the photographer. The only exception if his only job is to click. Because if you were the one who chose how you would all angle and look, it's not Kuya Waiter. But this Kuya Waiter who said, oy, compress, oy, patanggal ng flower vase, oy, wacky, jump shot, oy, di si Kuya Waiter na may-ari. We have a popular case of PETA versus Later. Who is this monkey? This is Naruto. And who took this picture of Naruto? It is the monkey. So the photographer is the monkey. In this case, which did not reach the Supreme Court, only hanggang level na parang RTC sa atin, the court, there had an amicable settlement between the two because the argument of PETA is that they are representing the wildlife. The Slater's argument is simple, nasan yung unggoy, and the unggoy has no legal personality. So this could have been a fine case had it gone up because monkeys do not have legal personality. Audiovisual works, cinematographic works. Okay, we have the case of ABS-CBN versus Boson. Why? Channel 2 has exclusivity in the arrival of Angelo de la Cruz. And Channel 7 tapped into routers, and routers was tapped by on Channel 2 because Channel 2 allowed routers to tap. So indirectly, Channel 7 tapped into Channel 2. Is there infringement? Obviously, yes, because it falls under audiovisual works, cinematographic works, etc. So pictorial illustrations, drawing stock, computer programs, and other laws. Since I said other laws, as opposed to patent and trademarks have more utility concept. But copyright has none. That is why, can you get copyright for porno? The answer is yes, because it will always fall under the argument of art. What is art is subjective. It can be trash now and art in another generation. Derivative work is a work based on a pre-existing work, like translation, dramatization, adaptation, or collections of literary, scholarly, artistic works which are original by reason of their selection. The case of Republic versus Tupas was asked in the last year's bar. This is about the PNP badge because the PNP asked Tupas to design for free the PNP badge. Why? Sabi ng PNP, ayaw na namin ng badge namin. Gusto namin, nandiyan pa rin yung badge pero ibahin. Nandiyan pa rin yung warriors. Sino yun? Sila Lapu-Lapu. Merong 8 rays of the sun. Ano yung 8 rays? Luzon. Yun yung 8 probinsya, Numakla sa Espanya. 3 stars, Luzon, Visayas, Mindanao. Shield, yung meron pa rin. Laurel, hindi yan dahil adobo. Laurel means peace. O basta, bahala ka na kung paano mag-arrange. Tupas arranged that. And when he registered it, it's PNP who asked for cancellation. What PNP owned is the original PNP badge. But the revised badge is a derivative work and it is owned by Tupas. Why? Because one who merely contributes idea, sausaw, is not the author. One who expresses the idea is the author. And Tupas is the one who made the new designs. Is the one who expressed the idea. That's why the idea is not the idea per se is public domain, but the expression of the idea, that is Tupas. This is not an example of commission work, because the PNP nagtipid. It did not pay. So this is not commission work. You cannot copyright those which are ideas. So example ko kanina, any idea is public domain. But once it is embodied in the form, then that is what is protected. Like if you have an idea of a superhero and that superhero has superpowers, has invisibility, etc., that's just an idea. But if you make the character look like, say, Iron Man, that is already protected by copyright, and that would be a violation if you copy that superhero. News of the day, I mentioned this earlier. News of the day is history happening now. Official text, ito, because we have central books with us. Sinirox mo ang SCRA, is that a violation of the copyright or is this allowed? That is a violation. Because SCRA is not the official text. that is a property of central bookstore. Because the official text has no annotations, kaya nga tinawag na SCRA eh. Yung A doon, hindi ako, it means annotations. Okay? Work of the government, but prior approval by the agency is necessary. Ito, may Justice Javier ruling tayo. Anong kwento? There were disseminated materials belonging to the National Archives of the Philippines. So, with the dissemination of these materials to the Bacoor LGU, because there's a training being held, a violation. First is, it was not shown who disseminated. And number two, the government has no copyright to its materials. The only requirement is prior approval of the government agency or office where the work is created is necessary. So here, since this is disseminated to the City of Bacoor stakeholders, this is presentation of the materials not for profit, but for the noble cause of improving the records management of the LGU. So this is one of the exceptions. What else? Those which copyright had already lapsed. If the copyright, example, I wrote an article published with the Japan Patent Office when I had a training. It is disnification. If the copyright had already lapsed, you can do anything that you want with it. Example, tingnan nyo ang Little Mermaid. Bakit ang Little Mermaid ay negra? Hindi naman negra yung si Ariel. Look at Snow White and the Seven Dwarfs. Bakit ang pangat-pangat ni Snow White? Ang ganda-ganda ng Queen. At iniba na ang kwento. What if you made a story? You made a fairy tale. You made it differently. The story of Little Mermaid instead of Serena na in love sa prince. Paano kung ginamit mo ay Shoke na Shokoy na in love sa prince? Can the heirs of Hans Christian Andersen complain? That is the reason why we have copyright which already lapsed. If it already lapsed, then you have no more control. That is why all of the Walt Disney stories are happily ever after, which is not correct. But no one can complain even if the story is written in a wrong way. Now, rules on copyright ownership is the same as trademark. You follow joint authorship or co-ownership. You also follow the rules in employer-employee relationship. But for commission work, there's a requirement. If your work is commissioned, what is owned by the one who commissioned is owned the physical object, not the copyright. So if you ask someone to do your painting, what you own then is the painting. But you cannot make another copy of that painting because the copyright remains with the author of the work. And when you say author of the work, there is a definition of terms, which is natural person when you say author. Why? I don't know if in the bar, magtatanong about artificial intelligence on copyright because when I had attended the colloquium on professors of intellectual property in Geneva, in 2023, much of the discussion of professors there are all about artificial intelligence. But for us, it's not really an issue because when we say author, we only mean to be a natural person. So artificial intelligence is X. So unless we see a revision of the intellectual property code to embrace definition of author to mean natural juridical person, then that's when I will have to make another answer. But now, wala, because it says the author is a natural person. If you submit an article for publication, that is only supposedly for a single publication. So if they make a compilation, that is also a violation. So let's go to rights conferred by copyright. These are twofold: economic as well as moral. Economic is where the money is. Reproduction of the work, dramatization, translation, adaptation, first public distribution, rental, kung inabutan yung Video City, matanda na talaga kayo, public display, and public performance. Okay, this is where we have a case on public display and public performance. If you upload something, by the way, in YouTube, and no one watches it, is that a public display? Yes, because it's making it available to the public, whether or not they watch it. In the case of Philippine Home Cable Holdings, they brought the home cable bought the Laserdisc, and these are available in its two channels, Home Pinoy Karaoke and Home English Karaoke. Is that communication to the public? Yes, because when the cable TV would transmit this composition, it's now available to anyone who watches the channel. So that is communication to the public. Even if there is a must carry rule under the NTC, it's different because what they are carrying are their own video laserdiscs, not those coming from Star TV and Cable Boss channel. For moral rights, on the other hand, moral rights are of two kinds. The moral right of attribution of authorship and the integrity. Because integrity is limited. Lifetime plus 50. So ito yung sinasabi ko kanina na fairy tale na ba muna ang kwento ng Snow White and the Seven Dwarfs. Pero yung attribution, the right to be recognized as the author, is forever. It will not be lost. Insofar as limitation on copyright, we have 3 musical copyright cases which discusses recitation. Accessible to the public, privately, free of charge, or made strictly for charitable or religious society. In the 3 musical copyright cases, Phil's Cap, Cossack, and Iceberg, the story are all simple. If the music is played to the radio and the restaurant uses loudspeaker so that the other areas can hear, is there a need to pay royalties? Or if there's a live band playing song, will they have to pay royalties as well? The answer to those questions is yes. Why? Because this is the doctrine of multiple performances. So when there's a reception of radio and then there is a reproduction through the using of this equipment, there's already another performance created. We cannot use the argument that it is fair use. Why? Because fair use requires private and free of charge or strictly for charitable religious society. Here, this is public, although free of charge, public, hindi siya private. There are 4 factors that we consider in the 4-factor test for fair use to apply. Like the nature, is it non-profit or commercial? Is it the nature of the copyrighted work? Was there transformation of the work? The amount and substantiality of the portion copied and the effect on the market, probable effects test. So with this test, these cases are illustrations where the 4-factor tests are not present. Although the US follows business exception and homestead exception, our intellectual property code does not have a similar provision. And worse, the TRIPS agreement is contrary to the business exception in the US copyright law. So unless we see the intellectual property code amended, for now, VILSCAP will have field time in collecting royalties in behalf of its clients. My paper is soon to be published next month by IBP Journal, and for the colloquium in Geneva, hindi ko pa alam dahil under peer review pa. Okay. So, fair use, na-discuss ko kanina ang 4-factor test, titigan na lang ito. Let's go now to infringement, the last topic. Infringement could either be direct infringement, or you benefit from the activity of another who had been given notice, as well as the right and ability to control, or with knowledge, causes, or contributes to the infringing conduct of another. So what if there is a mall operator, and the mall operator has tenants selling pirated materials? Is there then infringement? Well, the requirement is that there should not only be benefit from the receipt of rent. The other party should have been given notice and the ability to control. And that is where mall operators always have as an excuse. They do not have, although they benefit from the rent, they have been not given notice. And they have no ability to control. So, let's see now if this provision will be amended. But for bar purposes, tandaan itong regarding infringement. Good faith is not even a defense, but what will be the impact if you are in good faith? Then the amount of damages could perhaps be reduced equitably. So I hope I've summed up the important topics in these 4 core subjects. That's why thank you kung pinanood nyo to o binasa nyo. And again, you can grab a copy of my pre-week. Everything is there, kompleto. Iba kasi yung pinagdadaldal versus binabasa nyo, di ba? Kaya ka tayo ng orientation kung paano magbasa. And I hope to see you in court, but not in Victoria Court. Okay. Thank you.
Thank you, Judge, for that in-depth and informative discussion on commercial law. Now we have few questions brewing. So are you ready?
Ready. Parang kape brewing, ha?
So first question. In your opinion, what are the top 3 bar favorite topics in commercial law that you predict will be asked in this #AmazingBarTrader?
Okay, so let's start with corpo. Kasi based on experience, corpo is a favorite topic. But for me, siguro, if we will look at the Justice Xavier ruling, corporate opportunity doctrine. Why? If you have read the corporate opportunity doctrine, there are discussions there of Justice Xavier, debates there, you will see their decision. Pero, hindi siya ang ponente. So, for me, magandang source yan kasi landmark case yung Chang versus Tapros ruling. So, that for me is important. Sa insurance, for me, insurable interest, it is debtor-creditor relationship. Kasi may landmark case din on that matter. For me, kasi yung magandang itanong, yung application of the law per se, na hindi naman lagi natatanong. So, for intellectual property, musical copyright cases. Why? Because we have 3 landmark cases on that. And the matter is evolving. So, these are good questions, fertile questions.
Lastly, Judge, what advice would you give to bar examinees who have registered for the bar but are having doubts about taking the exam?
Diyos ko, kailan ka pa magiging ready? Taon-taon, nag-iiba ang coverage. Taon-taon din, nag-iiba ang examiner. There's no date na masasabi mong ready ka. You will always be not ready. So why not do it now? Ganon din naman ang ending. Diba? Pinatagal mo pa, tumanda ka pa. So, ayun na. That's it.
Thank you again, Judge. Your clear and detailed explanation of the topics truly help us grasp even the most difficult concepts in commercial law. We appreciate your time, effort, and expertise in what we have shared today. Were you reviewed and refreshed by that commercial law lecture by Judge Tambasacan? Don't worry, we have many lectures for you. To view other lectures, they are posted online, so kindly follow our page, Central Books PH, and Philippine Association of Law Schools, showing in your screens to be updated with the dates and latest updates on the lecture series. Once again, my name is Luis. I'm your host. Thank you and see you again on our next Central Bar Lectures. Bye!